um, our 8:30 calendar, McHugh versus McHugh, we had a issue in there that the court wanted to address. It is only for the emergency matter only. This is a hearing that in court anticipates will take me about 15 minutes. So that'll give you an idea of what I'm trying to look for. Okay. So let's see. We have Megan McHugh. Is Megan McHugh present with counsel?
She is Attorney Jones for Miss Megan McHugh.
All right. And then I have Dylan McHugh. Is it Dylan McHugh present? All right. And do you have counsel? Because
Yes,
I have okay. Lalila Bay, is Attorney Bay present?
No, Attorney Kevin Marks. I entered my appearance on April 2nd. It's the same office.
Okay. Kevin Marks. Okay, actually I do see it now. All right, so there was an emergency request of the court dealing with the standing order that came from the petitioner. That's the matter I'm taking a look at. So Ms. Jones.
I'll go quick because it's not probably that much of an emergency at this point. She kind of resolved some stuff last week on her own. It was a standing order. They weren't supposed to make changes to the auto insurance. She was removed. The vehicle that she primarily used, or the only vehicle she used, she was removed on the auto insurance, couldn't get any insurance. But just at the end of last week, she was able to on a different vehicle that she had to put on the road and get it. So that's why I did advise the court that it may not be as much of an emergency if we were getting on the calendar for a final hearing soon. And we could have just brought up the different changes at that time because she did just secure insurance on another vehicle, and you don't want to hear the contempt today, so we won't have to go over it. So briefly, the emergency portion of it was because the auto insurance was removed. It was removed back in October, then it was added back on, and then it was just again.
So where's that insurance? Because she shouldn't have to go get a new policy.
Well, he was the primary holder on it, and he removed her back in October, and then she called him and got back onto his policy. It covered the cars and the home, and then it was renewed all up until April. However, midway through, he jumped ship off of that insurance completely, and so in April, the total policy went away. And so the car that she was driving, Progressive did not continue the insurance because it was under his name. And since it was a Mercedes, it's luxury car, she wasn't able to secure insurance whatsoever for that vehicle. And so she just recently put like an engine in another car and got liability insurance under State Farm last week. So that was the emergency.
I don't know. Okay, and that's fine. If you're comfortable, you're comfortable. But as far as the standing order is concerned, your position is he took the insurance off the vehicle that she was driving. And you're not trying to get that insurance back on that vehicle. Is that what I'm trying
to say? She would, but I felt like as far as an emergency versus a contempt, she would like it, but he's no longer with that insurance company. He completely changed it.
Well, that's fine, but is insurance on the car?
Not that vehicle, no.
Okay. Is that the cars that she generally would be driving?
Yes.
Okay. And why you're in your position is now that that's not an issue? You're okay.
Well, I mean, it's an issue. I just didn't know if it was an emergency because, I mean, she needed a vehicle to get back and forth to work. She needed a vehicle because they have a minor child and she needed to be accessible. But it depends on if you're going to force them to put it back on and know that fall more under a consent versus emergency. Like emergency.
Well, it was an emergency when you have a vehicle that's not insured that someone is driving. That is an emergency. That's the reason why I had the hearing.
Right. And at the time when we filed it, yes, it was an emergency. That's just.
But your position is now she has something that she's comfortable with and can handle that and could stay in that vehicle and be comfortable until we have a hearing. Is that's what you're saying now?
I mean, I guess not necessarily because that one had full coverage on it as well. It was her primary vehicle that she drives, the Mercedes, and now she only has liability on a vehicle that is not hardly comparable to what she was driving. If the court is going to order him to put it back on, I'm pretty sure she don't want to drive what it is. She had to go put an engine in the car and try to get it working versus the car that she normally drives every day.
Okay, Mr. Marks, let me hear from you.
Sure, Judge. My client took her off of the insurance. He wasn't aware of the standing order. This was back prior to our representation, as far as I know. When I received the motion regarding emergency, I contacted him. He contacted the insurance company, and in doing so, he learned that she had, in fact, obtained coverage with State Farm. And so he did not add her back on. That appears to be confirmed by her financial affidavit that was provided and verified April 24th of this year. That indicated her expense for auto insurance is $35 per month. So I would concur that there is no longer an emergency situation in play. I would note that my client pays for all of the household expenses with no contribution from the petitioner in this matter. It was out of financial hardship and a lack of understanding that he removed her from the insurance. Again, he did take a step to add her back on. Learning that she had obtained her own and given his financial hardship, he did not add her on as he believed that it would be doubling up on the policy.
Well, I don't think so. So everything should remain status quo. If she was driving that vehicle, that's the vehicle she drives. If he had insurance on it, that's the insurance he has on it until the matter is resolved. Everything goes back to status quo. He needs to put her back
Okay.
on insurance. He needs to give her the car. That's that.
Will do.
All right. Well, and then you all can contact Ms. Marshall, and let me know where you all want to put it with regard to the final.
Okay, we do have some, I think, a motion to compel that has to be heard first. and
Okay.
get out.
Okay, I'll let Ms. Marshall know. She'll put it on account.
Thank you.
All right, thank you. I'll take care.
Thank you, Judge.
Good morning, everyone. This is Ms. Marshall, Judge Bear's Judicial Case Manager. I need all videos open, please. All videos open for the 9 a.m. calendar. This is a domestic calendar. This is a all-day calendar. All day. So when you get a break, if you need to contact any employers or daycare or anything of that nature, do it at that time. All videos open. If the court cannot see you, your case will not be heard. All videos open. These are official court proceedings. When I say official, I mean behave and present yourself as if you were officially in the courtroom. These are public proceedings. We are streaming live on YouTube. I'm sorry, Ms. McHugh, you're excused. You're on mute. We're streaming live on YouTube. The Zoom link, YouTube link, and password are available on the court's webpage. Because these are official court proceedings, you must adhere to and abide by professional courtroom decorum. That means no driving, no drinking, no lying in bed. Can't be at the dentist's office, can't be at the doctor's office. Can't be fixing the kids' breakfast, picking them up, or dropping them off from school. Find a place where you're comfortable, be seated, and be still. Ms. Burt, find a place, be seated, and be still, please.
Jeffrey Monk versus Anicia Hathaway Monk.
Good morning, Your Honor. Kimberly Blackwell for Jeffrey Monk. He is on the platform this morning. I do not see the respondent. It's a little difficult for me to give you a time announcement because we previously filed a motion to compel in this case. You allowed, you entered an order on that and allowed her an additional 10 days to respond. To date, we have not received responses. I was hoping that we can go into mediation this morning, but if Ms. Monk is not here, I'm not sure how that's going to be possible. I would like to note that the parties don't have any real property assets or debts between them. Child support is seemingly agreed upon, as my client has been paying support for the minor children. There are 4 children involved. The area of contention seems to be custody and parenting time. And so ideally, I would like to mediate, even though we don't have discovery responses, but I don't want this case to continue to linger. I know.
This is a custody case for which I gave her time to respond, and she's not here.
So it's a divorce, but yeah, the area of main contention between them is custody and parenting time.
I understand that, but that also means that she, if not being present, could lose custody. So I'm just okay.
Your Honor, I don't know if can I speak?
No, you can't.
Mr. Monks, just send me a message to let me know what you wanted to say.
Ms. Marshall, give Ms. Monk a call.
Yes, ma'am.
All right. Ladina, I'll come back to it, Ms. Blackwell.
Did you want me to do that now or after the call of the calendar?
After call of the calendar.
Yes,
Solemn
ma'am.
swear affirm the testimony about to give to this court is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Unmute Ms. Slaughter.
I do.
All right, thank you. So Ms. Slaughter, can you tell me about the parenting plan?
We share 50-50 custody. It's a 2-2-5-5. I have the boys Mondays and Tuesdays. He has them Wednesdays and Thursdays. We alternate weekends. We've been doing this since we separated in June 2022. It seems to work well. The boys like being able to see both of us at least twice a week. We text about the boys. Mostly everything is in writing. And aside from one hiccup this past summer, We haven't had like any major issues when it comes to making decisions for the kids.
All right, how do you handle medical appointments, dental appointments?
I usually take them to those appointments and then I send him information and let him know what happens. But if an appointment has to be scheduled on his parenting time, he's fine with taking them. And he would update me, but I don't think no, I've taken them the last 2 years for their appointment. Well, they haven't had their physicals yet this year, but I took them last year and I just text him any updates that he needed about their medical appointments, pretty much how it was when we were still together.
And Mrs. Slaughter, how do you handle teacher conferences?
Most teacher conferences, I feel like pretty much all the teacher conferences that we've had in the past few years have been on Zoom. So we both join the Zoom and listen to what the teachers have to say about the boys' progress. So that's how that's handled.
All right, and do y'all have dialogue with regard to how you're going to handle whatever issue came up from the teacher conference together?
Yes, we'll discuss it like Danielle said, usually via text, as to what we might need to do when the boys are with us to kind of advance their progress or whatever concerns their teachers might have that we need to address. So,
Do y'all talk?
you mean, do we have like actual conversations?
Yes.
Yes, we definitely
I was wondering, do you talk?
No, we do. We do have conversations. There's been times where I've dropped the boys off at her residence, and we've conversed. So it's not a situation where we don't talk to each other. I think um, last summer when we did have an incident, Danielle wanted to make sure that everything that we kind of discussed was in writing. So I think that's the reason why a lot of the things that are discussed are via text.
Okay, but you don't have trouble talking with each other.
No.
No.
And are there any issues with regard to, I think you talked about there was one pickup drop off issue that happened in the summer. And how was that resolved?
I mean, it wasn't necessarily, I don't feel like it was necessarily a pickup drop off issue. It was just there was I feel like a disagreement in some decisions that were made around insurance, and it kind of just caused a rift between us. The issue was rectified. It just took a little bit of time before we were comfortable with speaking in person. But that was this past summer, 2023. So we've conversed since then. Like I said, not too long ago, I dropped the boys off at her residence and helped her out with some things around her house. So the communication, I think, is pretty decent.
All right, and what is who makes major decisions with regard to health, medical, religion? Extra.
I have for most decisions, we talk in general about like if I see something that we want to we might want to put one of the boys in, I'll send it to him to see what he thinks about it. Or we talk about what the kids might have going on when it comes to that. But during mediation, we agreed on final decision making for health and education will be mine, and religion and extracurriculars will be his. We haven't raised our kids with religion, so that didn't seem to be something that would change for either of us. We wanted them to be able to pursue on their own time. So we've been able to kind of agree that neither of us will switch up certain things. I think as long as we stick to talking about the boys and not talking about us or why we failed as or not failed, but why our marriage is ending, we are okay, as long as it's just about the kids.
Okay, so there'll be no exchange of child support, Mrs. Slaughter?
No.
And what about insurance premiums? Who's taking care of that?
The boys are on my insurance.
Is your position that this marriage is irretrievably broken?
Yes.
And there's no hope for reconciliation?
No.
Is it your position, Mr. Slaughter, that the marriage is irretrievably broken?
I agree with what Danielle says.
You can't agree with Danielle says. You got to tell me. Do you think this marriage is irretrievably broken?
Yes.
Do you think that there's any hope for reconciliation?
No.
Then the court is gonna accept your domestic mediated agreement, your parenting plan, your child support agenda, and your child support worksheet, and the court will find that you are divorced with the right to remarry, and that these agreements shall become a part of the decree. We'll put these in the queue. Do not do anything inconsistent with the marriage until you received a copy of the decree. I'll just initial. And the parenting plans are in, the certificate. All right, thank you so much. You're free to leave.
Thank you, Honor. And thank you for taking the
Thank you.
time to speak with our client, with the parties.
Thank you, Your Honor.
Right?
Thank you.
Yes.
You've been a resident of the state of Georgia for more than 6 months prior to filing this action.
Yes.
Your spouse is Donovan Harkin. He's on this platform with you.
Yes.
You served him via share. Oh, no, you did not. Hold on. Personal service. Let's see. Yeah, personal service on June 13th, 2023. Is that correct?
Yes.
It's your position that there are no minor children born in the marriage?
No.
Are you currently pregnant?
No.
You were lawfully married on July 1st, 2017, separated on January 15th, 2023.
Yes.
You wish to have your name restored to Tabitha Tamiko Henderson.
Correct. Yes.
Henderson is your maiden name.
Yes.
You asked for the court to divorce you on the grounds that the marriage is irretrievably broken and adultery. If I divorce on the grounds of adultery, I would have to take evidence of that, which means you would have to prove adultery. We would take basically a hearing. Well, we could go into a hearing on it, but it would be an evidentiary hearing. Or I can divorce you on the grounds that the marriage is irretrievably broken. How do you wish the court to proceed?
I did submit evidence, but what was the second option?
Or I can just
Sorry.
divorce you on the grounds that the marriage is irretrievably broken.
Yes.
So you want me to divorce you just on those grounds, correct?
Yes, ma'am.
Is it your position that the marriage is irretrievably broken?
Yes.
Is there any hope of reconciliation?
No, ma'am.
Or is there any debt, liability, assets, and property to divide?
Well, I don't know. I don't know how we're supposed to work that because it was a big mess when I left. And we just haven't really been able to resolve that between the two of us. The main thing was, I guess, the house. 1 minute he said he was going to give it to me. He had left, but he came back and he moved downstairs. And he never left. So we remained roommates, but we had a big fight. And that's what caused me to leave the house because I didn't want to live like that.
So are you disputing the house? Do you want the court to hear who gets the house? Or are you conceding the house?
I don't know if I would have rights to it. It's in his name.
Okay. Did you divide before? Did he buy it before the marriage? After the marriage? Have you put money into it? I don't know. What do you got to tell me what you want me to do?
Yes, the down payment came from my 401k. All the closing costs, the maintenance of the house, everything I upkept of the house. He just recently, when I left, started putting into the house, other than, helping me with the monthly payments. But other than that, yes, everything I done.
Okay. That's what I'm asking you. Do you have evidence of what you put into the house that you want the court to consider for trial today?
I didn't submit it, but I can get it. My 401k statement and things.
You can't get it because today is the day.
Okay. Yes, ma'am.
You can talk about it. You can tell me certain things. Sometimes
yes, ma'am.
The court can accept your testimony as evidence sometimes. But
yes,
I don't know. I'm trying to figure out, do you want to have a full hearing on the house or not?
We can do that today. Yes, ma'am.
All right. I'm gonna so how much time do you think it'll be for the court? Because I'm gonna have to redo your numbers with regard to time.
Well, just what I have. It won't take me but a few minutes to just tell you, so maybe another 15 minutes.
Okay. And what about you, Mr. Hart?
Ma'am, okay, this is my house. I never left my house. I never left and came back. I've been staying in my house for the longest. I bought this house before we was married. And all I was saying, you know, I wanted to keep the house. When Tabitha left and she basically took everything out the house, and she basically told me she got everything she wanted. Only thing Tabitha left me here was I guess a bed, the living room set, and the TV. She left me upstairs. I had
Mr.
to
Hart,
ask
how
my
much
mother.
time do you think it'll be for the court to hear what you need to say about the house?
Yes, we might need more than 15 minutes because
How
ma'am,
much time? I just need to know the time so I can figure out where to put you.
30 minutes.
All right. So now you're at 45 minutes. I'm gonna have to come back to you. Okay.
Okay.
Right hand. Is Saku Williams present?
No, ma'am. Latasha.
Do you solemnly swear or affirm that the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth to help you God?
Yes, ma'am.
All right. You are Latasha Williams. You've been a resident of the state of Georgia for more than 6 months prior to filing this action.
Yes, ma'am.
Saku Williams is your spouse and he resides in DeKalb County, has filed a acknowledgement of service and jurisdiction of this court. Is that right?
Ma'am.
Is it your position that you were married June 8, 2006, separated on January 10, 2017? Is that your position? Ms. Williams?
Yes, can you hear me?
No, I can't. Is that your position on the dates of marriage and separation?
Yes.
There are 2 minor children born of the marriage. Is that right?
Yes, ma'am.
All right. And with regard to these children, you have completed a parenting plan that you wish the court to adopt. Is that right?
Yes, ma'am.
And that parenting plan does what?
Well, we've been doing this, I told you, for 7 years. So Monday, Tuesday, Wednesday, he has them, and Thursday, Friday, I have them, and sometimes he pick them up for school. So we co-parent. We work together with the kids. So we've been doing this for so long, but we just keep missing the court date.
What do you mean you've been doing this for so long?
Applying for a divorce. We went down there together to e-file, I think 3 times. So this is the 3rd time, just trying to get a divorce. But we co-parent with the kids. They are on his insurance. He has UPS insurance, so it's free. So that's why they are on his insurance. And Zion, he's about to turn 18 in October, but right now he's 17. And Trinity is 14. And our plan works very well.
You don't have a plan. You don't have. There's nothing in writing about Monday, Tuesday, Wednesday, Thursday, Friday. There's nothing here.
Oh, okay.
Where is the plan?
I think I said joint custody. I didn't know if I don't know why that's missing. I didn't know if that was on there or not, but that's what we've been doing for so long.
Yeah, you don't have a plan. I don't know. You guys kind of wrote down, I guess, what you wanted to write down, but not what you're actually doing. And so that's a problem because I can't.
Okay.
I don't know if you want that in writing or not from the court, because you can do Monday, Tuesday, Wednesday, but the document you submitted to me says that he's
Right.
on vacation. So when I sign that document, that becomes the order of the court. And if one day he didn't want to do Tuesday and Wednesday, he wouldn't have to, because that's not the court's order. It's something you all came up with. If you want the court to put in its writing what is required of you, then you got to tell me what you're actually doing.
Okay. Well, that'll be fine. I'm quite sure we won't have any kind of issues.
I know everybody is quite sure of that until they're not.
Yes, ma'am.
I'm not trying to be crass about it, but I mean, everybody divorcing, not everybody, but a lot of people say, oh, we won't have any issues. And then I see them two months later. Everybody wishes for that to be the case, but it's just how people are, and they end up with an issue. And then I have to resolve it. So I try to figure out a way of resolving the issue before it comes to me. And that's to be detailed about what it is that you're asking me to do. So I'm not gonna sign off on a every other weekend when I already know you're not doing that, because it's just gonna come back. When somebody gets ready to go to Disney World and the other parents say, no, that's my weekend.
Mhm.
So the plan that you're doing is what?
Monday, Tuesday, Wednesday,
And who,
And
that's in Monday, Tuesday, and Wednesday, children.
with school, and Thursday and Friday with me.
And that's
And
every Thursday and Friday?
yes, ma'am. And we alternate weekends.
Whose weekend is it this weekend?
It's his weekend.
So with regard to the child support, even though you're doing 50-50, because it's more than you, there is an offset for child support, which means that just because a lot of people will think, if I do 50-50, I don't have to pay child support, but it doesn't work that way. Child support goes to the person that has the lower income, because that person is considered by law the non-custodial parent, even though you're doing 50-50 split. That would be you, which means that even though you're doing 50-50, you could get child support.
Okay.
Do you want the court to consider that child support or not?
No.
All right. So basically, you want the court to indicate that you are basically giving up about $200 a month. Is that what you're telling me?
Yes.
All right. And who's paying for insurance?
It's free, but they're under school. It's free for UPS. He's still working.
What do you mean it's free?
They don't pay for their health insurance. So the kids are under his health insurance.
Okay. Under his health insurance free, what do you mean by that?
If you work for UPS, you don't have to pay for the health insurance.
Okay.
Yes,
So
ma'am.
UPS has a family health insurance plan where it's free.
Yes, ma'am.
So he's responsible for health insurance.
Yes, ma'am.
And what about after school care and aftercare?
I pay for that, but they go to the Boys and Girls Club. But it was like $100 a year. So I pay once a year for the membership.
$100 a year? Okay.
And my son, so I pay that for my daughter, but my son is free because he stays in Rockdale County, which is beautiful. So he goes there for free, but I had to pay the $100 for Trinity.
Okay, now I'm seeing another worksheet where you're saying you make $2,000. Now your income has gone up. What do you make?
So as you said, when we first filed it, we were staying in DeKalb. So now Conyers, I make $2,000 now. Now that's current now. So that's my current pay now.
Okay, so on your current pay, okay, so all right.
New job.
Okay. All right. And have you done the parenting seminar?
Yes.
Okay, I see that Mr. Williams has. I just don't see yours.
But I probably have to redo it because when I submitted it, I think they said it was expired. It has a year. Because remember, we've been going through this for a couple years now. So I did it on the first case that I didn't go to. And I did it twice. I think I did it twice. But not on this case number.
Okay, I'll give you 30 days to get that certificate in.
Okay. Yes, ma'am.
Okay, give me one moment. Is it your position that all your debt, liability, property, and assets been taken care of? Y'all already divided all property, assets, and debt?
Yes, ma'am.
I'm sorry, Your Honor, if I may give you a call on this case, please.
Yes, And Ms. Williams, what's your position on who makes final decision?
I do.
You make all final decisions. Okay, so we're gonna pull the documents together, ready for a final hearing. But Ms. Marshall indicated that Mr. Williams did not get notice in this case, so he did not get notice, which means that I cannot finalize the case without his approval.
He did know, and he got notice from his and we discussed it.
Yeah. So her notice though does not reflect that he received notice. Her notice indicates that she sent him a document, but the document did not attach. So he might have known. I think you probably recognize he might have known, but I don't know. Maybe if you think you can get him on.
Yes.
If you think you can get him on real quick.
Yes.
I'm sorry.
Yes, ma'am, I can.
All right. So you can get him on real quick. And then I already have everything kind of pulled together based on your assertion that you all have been doing this. And this is what he wants. So when he comes on, if he could he'll just verify that for me and then we'll have what we need. Okay.
Okay.
All right. Green.
April Green.
All right. What's your response to the swearing of the oath?
What do you mean?
What's your response to the oath I just gave you?
Oh, yeah, I do. I'm
All right.
sorry. Yes.
All right, place your hand down. All right, you are April Green, is that correct?
Yes.
You've been a resident of the state of Georgia for more than 6 months prior to filing this action.
Yes.
Veronica Reed is your spouse, is that right?
Yes.
And Ms. Reed, you acknowledge service of process and jurisdiction of this court. Wait a minute, don't have a signature on that page. No, no signature there. No service of process, no signature. Okay, where am I now? Okay, so fine. June 16, 2023, you were served. Is that correct?
Yes.
All right. All right. Is it your position then, Ms. Green, that you were separated, that you were married on December 10, 2019, separated on January 15, 2023?
Yes.
There are no minor children born in the marriage?
Actually, I didn't, when we had our pre-hearing, I didn't understand that question. We do have guardianship of a 12-year-old, but it was before the marriage.
You have a guardianship of a 12-year-old before the marriage, both of you, or just you?
Both of us, temporary guardianship.
Okay, and what's going on with that now?
He lives with me.
Huh?
He lives with me. She does insurance and she's sending me $200 a week.
Okay, so you have temporary guardianship that you both requested of a minor, and that temporary guardianship of this minor is for what period of time?
Until he's 18.
Okay, and right now the child is
12.
12.
Okay, yeah, that's gonna change the time frame for this request. All right, and you all had this guardianship before you were married?
Yes.
Yes.
All right, either of you pregnant now?
No.
No.
Other than the guardianship of the child, are there any other outstanding issues?
No.
No.
All right, have y'all resolved all outstanding issues of debt, liability, property, assets?
Yes.
Yes.
Okay, and with the child, have y'all come to an agreement with regard to visitation and things of that nature?
No.
Okay,
We had a plan set, but it wasn't consistent.
okay, yeah. Now, this is something we could have gone to mediation. You guys should have indicated mediation, because that's something you could have come through without a lot of court intervention. And I've already released the mediators.
Well, if she's willing, like, is there any way that we can tell you what we were doing and see if that, if she still agrees to that?
Yeah, I understand that, but that's all a part of court intervention. Just looking at time and stuff. Sometimes when we have mediators, I try to use the mediators so that the court's time can be better spent on more significant issues. Visitation is something you guys could try to come to a resolution on, and it just saves the court's time. That's all. Okay, Ms. Marshall, give me a call.
Yes, ma'am.
Ms. Reed, on the guardianship, do you receive any funds as a result of the guardianship?
No.
Okay. The guardianship, was that through defect, something you sought out, family, relationships?
Family.
One more time?
Family, and we've had him since birth.
Oh, so there's a family member who asked you to raise the child and gave you temporary guardianship since birth?
Yes.
Okay, and whose family is it? Connected to Ms. Green's family or your family?
Mine.
Okay. And Ms. Green, is your position to continue with the guardianship, is that right?
I just want to be able to visit him.
Yeah, my question though is that, is your position to continue with the guardianship?
Yeah, yes.
Okay. All right, we're gonna see if I can get someone with mediation in to assist. I want you to hold. All right, and on Latasha Williams, have you been able to get in, Mr. Williams? Latasha Williams, have you been able to get in, Mr. Williams? All right. Let's go to Catherine Sagaste May Rivera.
This is a divorce hearing. Mr. Rivera filed an answer, but we've not heard anything else from him. This is a marriage that it is a 2-year, well, actually it's 4 years now, but the parties separated December the 21st. And there is one child from that marriage. I believe he's about 3 years old. And Ms. Rivera has 2 older children from another relationship outside of the marriage, prior to the marriage. Your Honor, would you like for me to swear in the witness?
Yes.
Ms. Rivera, please raise your right hand. Do you swear that the testimony you will give will be the truth, nothing but the truth, so help you?
Yes.
Okay, you may lower your hand. Ma'am, are you the plaintiff in this action?
Yes.
And you're married to the defendant, Jesus Sagastome Rivera?
Yes.
And prior to the filing of this divorce complaint, had you been a resident of Georgia for at least 6 months?
Yes.
When did you get married?
October 22nd, 2020.
And when did you separate? Did you separate approximately December 2021?
Yes.
And you have, there's one child that was born of the marriage.
Yes.
What is his age and name?
Her name is Hannah, 2 years old. She'll be 3 in July.
And since the separation in December 2021, has the child lived with you?
Yes.
Have you been the primary, during marriage, were you the primary caretaker of the child?
Yes.
And you're seeking primary custody of your daughter from this marriage?
Yes.
Have you, since your separation from the defendant, have you received any child support?
No.
Is he working?
Yes.
Your Honor, I submitted 10 exhibits. I believe exhibit number.
Can you send those to me, Ms. Marshall?
Yes, ma'am.
I believe exhibit 9 is the financial affidavit of Mr.
Actually, can you share it, Mr. Coleman? That'll be easier.
That is something new. I clicked share. This is the financial affidavit.
Okay, yeah, thank you. We're able to see it. Before we do that real quick, I think we had a mediator just come through.
Okay.
Mediator Davis, are you here to assist me in one of the cases that I just called about? You're on mute.
Yes, Your Honor.
Thank you. All right, then. So, Ms. Marshall, can you help the Green versus Reed case? Go ahead, Mr. Coleman.
Okay, Your Honor, thank you. This is exhibit 9, which is the financial affidavit filed by Mr. Rivera at the time he filed the answer. And he states his income as $4,417 a month. Ms. Rivera, is that around the amount that you know him to be capable of earning? And was he earning at that level when you were living together?
Yes, that's about right.
And I'm sorry, what type of work does he do?
Construction.
You know, also exhibit 10 is the worksheet that was done based on the income Ms. Rivera stated in her financial affidavit and his income. We've submitted 2 check stubs as exhibit as well for Ms. Rivera to support her income. And the worksheet is calculated on those wages.
Okay. And what's the total? What's the amount of child support?
It is $696.
$696. Okay, thank you.
And there also was a credit for one of the children that Ms. Rivera had.
Okay.
A DVA.
All right, so just a little small for me, but okay, thank you. $696, and that's given credit. All right.
Ms. Rivera, are you pregnant with child at the moment?
No.
Okay. And as I said, you're asking for custody of the child with you and Mr. Rivera?
Yes.
And are you asking for child support based upon the child support worksheet that I just discussed?
Yes.
And that's $696 a month?
Yes,
Okay, and the child is currently insured by public insurance, public
yes,
assistance insurance. You and Mr. Rivera, have y'all divided your property, and you're satisfied with what you have, and that's what you're interested in keeping?
yes,
And that's the same as well as the marital debts?
yes,
You want him responsible for what's in his name, and you're responsible for what's in your name.
yes,
Now, was there domestic violence during your marriage?
yes,
And did that have anything to do with your separation?
yes,
Are you asking for a permanent restraining order with regards?
no,
You're not? You're not
oh,
asking-
yes, yes,
Okay.
Okay, well, if you're asking for a permanent restraining order, you're gonna have to give me details of the violence.
Your Honor, let me get up a couple of,
I'm sorry, say that one more time, sir.
I'm gonna pull up a couple of exhibits. That
Okay,
Photographs.
all right.
Ms. Rivera, can you briefly testify regarding the violence you have experienced during the marriage at the hand of Mr. Rivera?
yes. I had gotten those bruises one night when he was drinking beer a lot, and he just started an argument with me, pushing me. I was on the bed and he just repeatedly kept punching me. So, and that's how I got
What
those
was
bruises.
it? Were you pregnant with your child at that time?
Yes,
Around what was the date of this violence?
I believe it was May 2021.
Okay, now the photographs that I'm scrolling through, who took these photographs?
I did.
And were they taken at the time of the violence or shortly after that?
Shortly after.
And does it accurately reflect the injuries that you suffered from his physical assault?
Yes.
Did the situation get any better after this incident?
No.
Does he have any problem with drinking excessively?
Yes.
And what effect does the drinking have on him?
He would just drink a lot, start fights with me, start arguments with me. I'd be on the phone, on Facebook. He claimed that I was talking to somebody else when I'm not. And that's how he always get physical with me when he's drinking.
Are you concerned about your future safety?
No,
You're not? Okay.
no.
Did I withdraw my request?
Okay.
Let me ask you this. Do you want the permanent restraining order, Ms. Rivera, at this time?
No, no.
Okay. Are you asking that the court restore your maiden name? And
Yes.
it's your position that the marriage is irretrievably broken?
Yes.
Is there any chance of you and Mr. Rivera reconciling?
No.
And so at this point, you're asking for divorce? And
Yeah.
I think that since Mr. Rivera has not appeared on the call of this case, that he'd be required to petition the court for visitation.
Okay.
Is
Yeah,
that what you want, or do you want to have some visitation already carved out?
He can go through court for visitation. Yeah. Oh, actually, no, I will help. He can see his daughter every other weekend like we're doing right now.
okay.
Yeah.
So every other weekend, what about holidays?
Holidays, we can rotate.
Okay, and how much time in the summer, if any?
The summertime, I mean, we live close to each other, like 30 minutes, so we
Okay,
will still
so
rotate
3 weeks in
every
the
other
summer?
weekend. Yeah.
So we'll do the every other weekend. Do you want him to have visitation time where he has 2 weeks of time, just him and his daughter, and you don't visit and no one's, during that 2 week time period? Do you want time periods like that, 2 weeks, 3 weeks? Do you want something like
No,
that?
no.
So what type of visit? Like, for example, if you want to take the kid out to go to Disney World for a week, would that be okay?
No.
Just a little background on that. There's a hospital, Exhibit 1 is a hospital report where the child fell off a second floor balcony while she was in the custody of the defendant. It's reflected in the hospital records. So I think Ms. Rivera's position is that every other weekend visitation would be sufficient.
I can't hear you. That every other weekend visitation is sufficient?
Yes.
Okay, so
and
no
not any-
no
not any
extended
longer.
summer,
Yeah.
no extended summer visitation without petitioning the court.
That's correct.
Is that what you wish?
Yes.
Okay.
And Your Honor, that's our case.
All right. So with regard to these requests, I'm assuming, Mr. Coleman, that you have the documents for the court to sign, or have you sent them to me, or was it?
Your Honor, if I could have a couple of days to submit.
Okay.
I didn't know whether he was going to appear or not.
Can you say that one more time?
I did not know whether he was going to, I'm sorry. I did not know whether he was going to appear or not.
Okay.
For the
All
final.
right. Yeah, if you would submit those to me, so for review, do not do anything inconsistent with divorce, Ms. Barrios, until I received it and signed off on the divorce based on the request that you've made.
Okay.
Okay, what day would I get on, Mr. Coleman?
Your Honor, would Monday work? That would be I believe that's the 13th.
Okay, Monday the 13th.
Yes, sure. Am I a little bit clearer? I guess I got to work on my mic here.
Yeah, and I think I might have some in and out issues myself, according to my staff. So, all right, so I'm going to give you Monday documents. All right, thank you so much. You're free to leave.
All right, thank you, Your Honor. Have a good day.
All right, let me go back to Williams. Latasha Williams, Sekou Williams.
Your Honor, if I may.
Yes.
I was just on the phone with Miss Williams. She was going to Mr. Williams' location, and I resent the Zoom link and password. I just got off the phone with her.
All right, so we're waiting on that one.
Thank you.
All right. Miss Blackwell, I'm starting with Monk.
Your Honor, this case is a divorce with 4 minor children. As I stated earlier, the area of contention for them is the custody and parenting time. I was hoping that Ms. Monk would be here so that we could go into mediation. I believe the parenting time and custody piece is going to be heavily litigated, and I think it would benefit from mediation. So at this particular time, I would beg the court's indulgence and ask for a mediation order with the parties having to attend mediation within 30 days, not to exceed 45.
Okay, I'll do that only because I hate to do one thing and then she's gonna already know. She's gonna come back and say, I didn't get notice. I didn't know. It's
Right.
a big deal. So I think you're right. Probably the best thing to do is to put it on the calendar again, reset it for a mediation order. Let's see what we get. Hopefully she'll kind of understand the importance of getting it done rather than spending most of our time kind of fighting through that piece. So I'll do that.
Honor, the issue of the motion to compel, of course, she still has not complied with that. I'm not going to ask for attorney fees at this particular point. I'll reserve that to a final. But I will ask for sanction that her answer and counterclaim be stricken pursuant to 9/11/37. And of course, the court has the discretion to say yay or nay. But that is my request.
All right, you could submit your order for that as well.
Okay. Thank you, Your Honor.
Actually, so it looks like I got just bought some time back. Ms. Marsha, can you see if you can get Hart versus Henderson back on? Actually, if you would, see if you can get Hart versus Henderson back on. Okay, go ahead, Ms. Blackwell.
Yes, ma'am.
Okay. I'm sorry, Your Honor. Let me switch gears a little bit. So short v. short, this is also a divorce. Parties were married in 2008, separated in 2015. My client filed his petition for divorce in April of 2023. Ms. Short was served by private process server on April 23rd. She has not filed an answer or a counterclaim. There are 2 minor children as a result of the marriage. The children currently live with Mr. Short. He's asking for sole legal and physical custody. They've been in his care for a significant period of time without mom exercising any consistent visitation. The reason why he's asking for sole legal and physical, with the visitation being at his discretion, the reason why he's asking for that is that mom has a history of substance abuse, and we do not believe her to be sober at this particular time, nor has she had any regular contact with the children for a number of years. I do believe after I spoke with him, his 13-year-old does not want to speak to her at all. The 11-year-old speaks to her sometimes, but is not wanting to see her. So of course, my client can provide a little bit more testimony as it relates to that, so that the court can have a clear picture.
All right, let's swear him in so we can get testimony related to that.
Okay, Mr. Short, please raise your right hand. And were you married on November 30th, 2008?
Yes, I was.
And you separated sometime in May of 2015, correct?
Yes.
And to your best of your knowledge, is your wife currently pregnant?
No.
And there are 2 children born of the marriage, correct?
Yes.
And with whom do the children live?
The children live with me.
And how long have they been in your care?
For a little over a year now.
Okay. And you understand that there's a difference between legal custody and physical custody, correct?
Yes.
And that the legal custody refers to the decision-making?
Yes.
Are you asking this court for sole legal custody as it relates to the decision-making for the children?
Yes, I am.
Do you currently have any conversation with your wife about the children?
No, I don't.
Does she participate in any of the decision-making as it relates to education, non-emergency health care, religious upbringing, or extracurricular activities?
No, she doesn't.
And when it comes to physical custody, I apologize if you all hear my dogs barking, but I can't help it.
No, we don't.
Okay, good. When it comes to physical custody, Mr. Short, are you asking for sole physical custody?
Yes, I am.
Okay. Sorry. And you said the children lived with you for a little over a year. Where did they live prior to?
Prior to that, they lived with my sister and also my mom before she passed.
And you all separated in 2015, correct? When did they go to live with your mom?
Going into 2016, January of 2016, they started living with my mom.
Okay. And then has your wife exercised any parenting time or visitation with the children?
She was here and there. Sometimes she would pop up. Sometimes you wouldn't hear from her for months at a time.
Do you know why that was?
I think she was struggling, with substance abuse and just poor decision-making skills as far as what she was putting in her body and doing to her body.
Do you know if she's attended any drug or alcohol treatment?
She left the state to go to Minnesota, and she attended a rehab, to my understanding, but then she relapsed once again.
And has she had any contact with the children since returning from Minnesota?
Yes, via text message, and she has seen them one time, and that's been pretty much it.
To the best of your knowledge, can you speak to her behavior when she did see them or when she does communicate with them via text?
Well, when she did actually show up, she showed up late at night, was beating on the door. I do have a homeowners association, so to kind of kill the noise, I opened the door, and she was intoxicated. I asked her not to pop up over here at the house in the middle of the night. It's no problem. She can call if she wants to see the children. It's no problem. Just don't pop up here in the middle of the night. And that was the last time I heard from her until a recent conversation where she was asking about Mother's Day, stating to my oldest daughter, if she doesn't see her on Mother's Day, then somebody's going to get cut, which I thought was kind of crazy. But again, I don't know if she was intoxicated at the time or what, but that's just not safe behavior to have around the children. I just wanted to get their life together,
Yeah. And have there been any issues with the children in your care?
No, everything's been smooth. Kids are doing great. Ruby's cheerleading. Prior to this, she's doing track. She got third in the state for Clayton County, so she's doing really good with that. Now she's going to do cheerleading. Haley, she's into art. So I'm just trying to continue to provide them with the things they need to succeed so they have their fair chance at life.
Okay. So do you believe that you having sole physical custody of the children, sole physical custody of the children and sole legal custody of the children would be in your best interest?
Yes.
Okay. Mr. Short, when it comes to your current employment, where do you currently work?
I have my own business. It's a transportation company.
And do you recall completing a document to ask you about your monthly expenses?
Yes.
And to your knowledge, that financial affidavit has been filed with the court, correct?
Yes.
And as far as healthcare is concerned, who covers the children on health insurance?
Right now, the kids are covered through Peach Care.
Okay. And so let me back up a little bit. When it comes to child support, is there an existing child support order?
Yes, there is. It's in Rockdale County.
And that order is actually requiring you to pay support, correct?
Yes.
Okay. And you're also wanting that case to be closed and dismissed, correct?
Yes.
Are you asking that the court consider the child support worksheet that was filed on your behalf?
Yes.
Okay. And can you state for the court your current income?
My current income is right around $2,500 a month.
Okay. Do you know if your wife currently works?
I don't think she works right now.
Okay. Mr. Short, do you have any joint property with your wife?
No, I don't.
Any joint debts?
No, I don't.
Are you asking to be awarded your personal property that is in your possession?
Yes, I am.
Are you asking for any items that are in the possession of your wife?
No, I'm not.
Are you making any claim to any assets that she may have?
No, I'm not.
Do you believe at this time that the marriage is irretrievably broken?
Yes, I do.
And is there any hope for reconciliation?
No, there's not.
Your Honor, that is our case at the time.
Now, with regard to the Rockdale County case being dismissed, how many years are they indicating? Because that's going to be a little difficult for me to do, because I don't, what's the time frame for the child support?
So, Your Honor, that case, when I look back at the history, I believe that is a 2018 case. And so Mr. Short can kind of speak to his ability to pay. I do know that there was a time period between 2019, is it till 2021, Mr. Short?
2022.
2022, in which Mr. Short was incarcerated. So hence why the children lived with his mom and his sister. So he did unfortunately incur arrears during that time. Just lack of knowledge on his part as far as trying to have that modified during his incarceration. But that case is still currently open. From my understanding and looking at the court docket, they keep resetting the case to be heard because I think they're wanting to hear what happens in the divorce as far as his custody is concerned.
So yeah, I can indicate that child support is no longer necessary, but I can't dismiss that case and indicate the funds that were accumulating since 2008 he's not responsible for, because he is responsible for them. And so I don't think I can do that. I can do, obviously from this point forward, there won't be any child support. But I can't first of all, it's a Rockdale County case. But I can indicate that he is no longer responsible for child support, but I can't eradicate the child support debt that he has.
I think what they're looking for is his order of custody for the children.
Yeah, and I can give him an order of custody. I just can't. And Rockdale will do what Rockdale will do if they want, however they decide to feel to take care of that. But if he owes money from 2018, then that's money he owes. And if they want to do some sort of offset as to what she would be owing from this point forward, I don't know. That's something, but that they're going to have to handle that in Rockdale.
Okay.
Other than that, if you would prepare the documents for me.
All right, no problem. Your Honor, when would you like for me to get them?
When can you get them in?
I'm considering that I have them. I can have them to you by tomorrow.
All right. Thank you.
Thank you, Your Honor. May we be excused?
Yes, you may be excused.
Thank you.
To give to the court is the truth, the whole
Thank you,
truth,
Your Honor.
but the truth, so help you God.
Yes, ma'am.
All right. So
Yes,
Ms.
Your Honor.
Williams was on indicating that you knew about the hearing, that you were aware of the position that you were taking, that you guys all outstanding issues of debt, liability, property, and assets been taken care of. That means you're not fighting over any money or any debt.
No, ma'am.
They split everything. And with regard to child support, you're splitting that there'll be no child support because you all have a plan where you have a children Monday, Tuesday, and Wednesday. She has a child on Thursday, Friday, and you alternate weekends.
Yes.
Okay. Is it your position that the marriage is irretrievably broken?
Yes, ma'am.
Is there any hope for reconciliation?
No.
All right, I think those are, Ms. Harris, was there anything else on those with regard to Williams versus Williams that I was concerned about before I release them?
I believe that's all those hearings.
Okay. And we'll be alternating holidays as well. So do not do anything inconsistent until you receive a copy of the decree. All right, is there anything else, Ms. Williams?
I don't think she.
No, ma'am.
All right, you're free to leave.
All right. Hey.
Your Honor, the parties met mediation. Attorney Fuller is here. I'll let her speak on behalf of the case and her client.
Okay.
Judge, I think we could call it a partial agreement, but we need the court's assistance on a few details. I don't think we have much to hash out, but we do have an impasse as to some factors in the parenting plan.
All right, let's take a look at those. All right. And Mr. Kimmel, you're free to leave.
Great,
Thank you, Mr. Kimmel.
Great, thank you.
Just by way of background, Your Honor, this case involves a minor child. She's 7 years old. Prior to this action, the parties were doing their own co-parenting. At some point, I believe 2022, there was a physical altercation that ensued and Miss Day was arrested. There was a case that was just resolved in Clayton County. She did do an offered plea to that family violence battery. They did set a non-violent no violent contact with the parties. Prior to that, they had a no contact provision. As a result of that, Mr. Smith hadn't seen his child for some months, several months. So now that the Clayton County case has been resolved, they ordered her to do a mental health evaluation, parenting class, and a family violence intervention program. Mr. Smith was asking for primary physical custody. We're not doing that. What he's asking is for her to have as much contact with the child. He did move for a brief period of time. He came back to Georgia. He's living about 15 minutes, 10 to 15 minutes from where Miss Day is living. So he wants to do, they've agreed actually to do 2 weekends per month. A standard visitation schedule, 2 weekends per month. We're asking for 4 weekends, 4 weeks in the summer, 2 and 2, two non-consecutive weeks. Mom has agreed that dad would have it's sort of a joint custody arrangement where mom would have primary physical, dad would be secondary. He would have final say so as to extracurricular and religion. Mom would have education and non-emergency help. They would use our family wizard to communicate. We believe the child needs to be in counseling. She did witness the altercation and she's showing some signs that she does need to counsel. They're in agreement to that. We're in agreement that, so at this point, our issue is because of the nature of the relationship between the parties, Judge, dad would we're asking the court if the court would allow dad to pick up the child at school on Friday and return her to school. Mom wants to meet Friday evening at a police department. I don't think that's best for the child. She's been traumatized to some degree. I think the less contact the parties have would be the better. If they do have to do an exchange because there's no school in session, we'd ask that Mr. Smith's wife or his mom would do the exchange instead of him. Miss Day's concerned that there's going to be some issues between the two of them. Our position is just eradicate the possibilities, just don't have them have contact with each other. This was a pretty substantial criminal case in Clayton County. And so we'd say
What do you mean substantial criminal case?
She hit him in the face and cut him. She was charged with, I believe, 4 counts of family violence battery, to the point where they said that she needed mental health evaluation and treatment. And so it was a one-time incident. We can't substantiate that it's going to happen or it's happened multiple times. But to alleviate
any, it has happened multiple times, or you're saying
no, Judge, we're saying it hasn't happened.
Has not.
It's just this one occasion. As such, we're asking, we feel that keeping the parties apart would be beneficial for them, for the child. We're saying if he picked up the child at school, he's been involved in the child's life. She has a relationship with him. And so we feel that if he picked her up at school and returned her to school, that would really reduce the amount or the incidences of them having contact with each other. I don't want to say they don't like each other, they don't get along. And so we feel that if he can't do the exchange at school, then his wife, he has another child, that the wife could do the exchange or mom could do the exchange. We're also, I mentioned our family wizard as well. My client is willing to pay for that because again, they really shouldn't have much contact. And there's a criminal case sentencing that says she can't have any violent contact with Mr. Smith. So we'd say our family wizard would be the only way they communicate unless it's an emergency. And so that would, at this point, we believe that would wrap up the case if we could reach a resolution as to those provisions. Okay, Ms. Day.
How you doing, Your Honor?
Hello.
I would like to state that my plea deal was under North Carolina versus Alfred, so I was not pleading guilty. From what my public defender explained to me, if I were to go upon a jury and be considered guilty, I would be at risk for having some jail time. And as you're already aware, I'm a full-time mother, so I did not want to risk going to jail. So I made the conscious decision to move forward with taking a plea deal. Within the plea deal, as Attorney Fuller stated before, I am on 12 months probation. I do have to go under a mental health evaluation. Also, I have to take a parenting class as well as a family violence intervention class. I did speak with the mediator, Mr. Kimmel, and also Ms. Fuller, and I did suggest that Jadiel take those classes as well. I believe that it will align with what we're trying to accomplish in the future with having a successful co-parenting relationship. As far as the meeting at a police precinct, I believe that it would be at best interest for not only myself, but for him. This was recommended to attorneys that I have gone through speaking with, because
what's the objection to the school?
For the school, because Jadiel is a truck driver, and also Basil has an IEP in school. So I want to make sure that her attendance is up to par. I want to make sure that she's being picked up on time as well. And there have been inconsistencies with picking up and dropping off with Jadiel in the past.
Okay. And when you say inconsistencies, what are we talking about? She the only one to midnight, or are we talking about just not on time?
Not on time. Their hours, saying, okay, hey, well, I'll be here at 6, and not communicating and showing up until 10 o'clock at night. So with
10
her
o'clock at night to get her from school?
Well, I'm saying as far as previously with him picking her up, he's never picked her up never really picked her up consistently from school. I've been responsible for that.
But what I'm asking you is, if he's indicating now he wants to pick her up from school to prevent you from having to meet like at a police station, I'm trying to understand why you have a problem with that, because clearly if he's not getting her on time, you wouldn't have to recognize or notice that. It would be recognized and noticed by the school. And that's something contempt, and we can handle that when it happens.
Okay.
I'm trying to figure out why not give him the opportunity to do that, because to me, I would want my kid to be picked up at school rather than a police station, because that's going to keep in the back of her mind the fact that you all, every single time you have that meeting, it's just the kind of another nod that you all are not in agreement, don't trust each other to the extent that you're at a police station. So I try not to meet at a police station unless like that's the only option you have for safety and security. And since at least what it sounds like I've heard, that you all have not had any domestic issues previously.
We have.
You are, said it again?
Yes, Your Honor. I'm sorry, I didn't mean to interrupt you, but yes, we have. For the record, we have had
other incidents of domestic.
Yes, other incidents that have not been reported to the police, but I do have statements from friends where they have witnessed Jadiel attempt to fight me, and they've had to intervene and separate us.
Okay.
So yes, this case that I had with Clayton County, I ended up going to jail for because I defended myself. And of course, previously there have been domestic violence issues, but luckily I have had family and friends to intervene to keep him from attacking me.
Okay. And I guess that's also just another nod in the direction of perhaps letting him pick her up from school, because then you you just have less interaction, to the extent that he's being late for school, he's not picking the kid up, this child is by herself. Those are contempt actions you can bring before the court and we can resolve it. I would say first, let's try to get the kid so that it's a normal thing, and she's not involving the police, and she can try to do her best to have some normalcy with regard to this new dynamic. Mom and dad not together. Mom and dad has to split custody. So I think the school would probably be the best circumstance. But to the extent that he is late and not picking the kid up, and trust me, the school will let you know, and that would be the evidence that you would need for the court to reconsider that issue. So I think the school would probably be the best route to go.
Okay.
All right. And what was your position on, what was the other issue?
The summer. Judge, he hasn't seen her. We're just asking. Part of this is he wants to be able to spend some quality time with his daughter, have some vacation with her in the summer. We're asking for two-week periods in the summer where he can have her consistently. They live relatively close. If she has camp or summer activities, and she has a sibling, so that she can spend some uninterrupted time with dad and then go back to mom.
Dad has another child?
Yes, Your Honor.
All right. What about mom? Do you have another child, or is it just?
No, Your Honor. It's just Basil.
Just Basil. And Basil is how old again?
She's 7.
7. What grade?
Second
grade. All right. So tell me what your thoughts are about the visitation during the summer?
For the visitation, it is a bit aggressive for me due to the history. I had no problem with doing non-consecutive weeks. He have her for a week in the summer. I have her for a week in the summer. But being apart from her for that long, for a 2-week period, is a bit aggressive for me, Your Honor.
Now, for the non-consecutive weeks, would you, if you would have opportunity to have phone conversations and also on a detailed itinerary, what would that do? In other words, if he'd take her to Disney World or whatever, he would tell you, here's where we're staying, here's the address, here's the hotel. who we're staying with, more detailed information to the extent that his visitation is going to be out of his home. So I guess first, if he had 2 weeks in June and 2 weeks in July, if you could have conversations by phone, would that solve the issue? And if not, would having detailed information to the extent the child leaves the home for extended visitation also be helpful?
Yes, Your Honor, that would be helpful. Me being able to at least, speak with her, and also having a detailed itinerary, like location, where she would be, that would definitely ease my spirits.
Okay. Okay, so now let me go back to you, Ms. Day, and your client. How would your client feel about having mom be able to speak with her on a daily basis during the visitation?
I think we can put some language in there that she can FaceTime or for 30 minutes. I think at 7, she's probably able to pick up the device and FaceTime mom. And as long as it's not disruptive, we said she can speak freely with her mom, Judge.
Right. So like, for example, if they're going to Disney World and they're going to be there from, 8 o'clock to 9 o'clock at night, you may not get your 7 p.m. call because she's at Disney World. But as long as you have some, consistent communication with your daughter, because generally what I normally do, Ms. Day, is about around 5, I start considering consecutive time. So before 5, I understand that might be disruptive to the child because the child has to learn to be away from the primary parent. And so I usually do like, okay, forces every other weekend, and then you do 5 days, and then you do 7 consecutive. I try to build on that when we have a parent that's, just starting a relationship with the child. And then, but by 7, consecutive time is kind of, I allow it because by 7, a child is articulate, generally can tell you how things went. If they miss you, they can pick up the phone and call you. And so generally around this time, I do allow consecutive. And I think 2 weeks each month is not significantly bad. What I'll do though is give each one of you the opportunity to pick those 2 weeks first. So for example, in the odd year, I might say dad can pick his 2 weeks first. In the even years, you get to pick your 2 weeks first. That way during the summer, if you wanted to, if one year dad had July 4th, but next year you want it, you could take it if you wanted, and you wouldn't lose out on, what we would say good weeks during the summer. Or if you had a family reunion and your family reunion is during the odd years or the even years, then and you want those weeks, you can also take those. Do you know whether you want odd or even years?
I would say,
or how your family might even meet.
For right now, I'm not going to say for right now because I know that this is going to be a court order. So I would say I can do even.
Okay.
I'll do even.
So even, which means would be this summer. So you would choose the first 2 weeks you want in June. You would choose the first 2 weeks you want in July. The child is always with mom the week before school begins. Okay.
Okay.
And so did y'all come to a holiday schedule? Or do you want me to do my odd even holiday schedule?
We did agree that it was going to be an odd even holiday schedule.
But did you check it off though? Has it already been checked off, or do you want me to go?
You can go through it, Judge, because I didn't check it off.
Okay. All right, so we'll do even. Are there any particular holidays of vacation, any type of religious considerations that the court may not be mindful of? Do you have?
No, Judge.
All right.
Well, I would like to say that Jadiel is Jehovah's Witness.
Okay.
So, I'm not really too certain.
Okay. So I'll have Christmas in there, but you guys do what you do. For example, if you wanted to switch that up and it really is not a big deal to you, you can do what you want, but because generally we always use Christmas, but is there other holiday that you might celebrate that is not mainstream that I need to be mindful of?
Outside of Christmas, I would say Thanksgiving. I know
I already have that checked off. We always do Thanksgiving. 1 year you'll have Thanksgiving, 1 year he'll have Thanksgiving.
Okay.
Nothing we did agree, Judge, that each party would have time with the child on the child's birthday and on their respective birthday. We said 4 hours.
Okay. And Mother's Day, Father's Day.
And Father's, yeah.
All right. So, Ms. Fuller, can you send me, did Mr. Kimmel give you a document that kind of goes over the things that you all resolved so I can look at that?
No, I started the proposed parenting plan that I could send you.
Okay, send that to me then. Okay, so y'all agreed on legitimation. What about the child support?
There is an order for child support through the agency.
Okay, and what's that? Do you have that child? Is that in the parenting plan that you were preparing?
It would be incorporated into the final order.
Okay, what is that child support number? Do you have?
$273 per month.
How much?
$273.
And do you have the case number and where is
I
it?
do have, it's, one second, Judge. Yeah, I do have a copy of it.
Okay, so basically I'll adopt the child support from Clayton County to 273. You all will alternate so what weekend is it? First, third, fifth? What is it? Or first, third?
Well, we're gonna do it has to be first and third because we want the order to start next weekend. This is Mother's Day weekend, so mom gets this first weekend.
Okay, so it'll be first and third weekend.
First and third, ma'am.
Okay, pick up from school, return to school on what, Monday?
Monday at 9, or if I would propose that if school is not in session, then we meet at a Publix or a Walmart parking lot.
Now, if school is not in session, based on what Ms. Day feel, I will go ahead with the police department if school.
Okay. And then if we do that, Judge, can we do the mom or the wife doing the exchange? Apparently she gets along with them better.
Okay, mom or girlfriend is fine.
His wife, yeah, he's married. So his wife or his mom could do the exchange as well.
Ms. Day,
yeah, I honestly don't get along with his mother or his wife. So if it is Jadiel, he is her father, and just like I'm her mother. So I would prefer it be Jadiel. I don't want to bring any other third parties that I have a history of not getting along with.
Okay, so apparently there's this history. So it's probably best not to bring them in.
That's fine, Judge.
All
So
right.
we'll meet at the police department and we'll find a location.
All right, so for the police department, which one? Which police department?
Which precinct is close to you guys?
I believe it's the Riverdale precinct. That's not too far from us.
Okay, so you're in Clayton County.
Yes, ma'am.
Or Mr. Smith, you're in DeKalb?
Oh no, I used to live.
No,
in
ma'am, I'm in Clayton County as well. Miss Day had recently lost her house, so she's with her mother in Clayton County.
Okay.
I didn't lose
you were
my house, Your
started here in
Honor.
DeKalb then?
It started in DeKalb. They were in DeKalb.
Yes.
Okay, so so Riverdale is the closest precinct?
Yes, from where I am, I moved from DeKalb County to Clayton County with my mother temporarily, and I'm staying there. So the closest police precinct would be the Riverdale precinct. There's actually a fire station that's right next to
Can
the
you get
police
that address,
precinct.
put that in there, Ms. Fuller, as well?
Yes, off High Road. I'll get that address, Judge.
All right. All right, anything else?
I think that's it. Now, just a thought, Judge. I did ask her. I did want to put the provisions of the special conditions of the sentence,
okay,
the FVIP and the mental health evaluation and the parenting class, unless you think it's redundant. Those were things.
Say that one more time. What do you want to do?
In the sentencing for the Clayton County criminal case, they ordered her to do the mental health evaluation.
Yeah, but I'm not, if that's not a part of my thing, that doesn't need to be in her. That's dealing with criminal. So
Yeah,
if she
I got it.
violate that, it wouldn't violate my order. That would be something she violate criminally. But I do think that it would be good to do the parenting, divorcing parenting seminar. That would be very helpful since they already have this antagonistic. I do agree with that.
They will agree to that as well.
Okay.
Your Honor, I apologize for interrupting. I just had a question.
Uh-huh.
So for that particular class, because I know you said divorcing parent,
Yeah, that's
Johnny.
what it's called.
Okay.
Yeah, but they can address people who are not married because the whole idea is really just how to handle a child with parents who are now not together and they have to learn how to communicate.
Okay, and would that be required? And the only reason I'm asking is because for my other case, I'm going to spend about $2,000 for everything that I have to get done. So could I possibly use my certificate or whatever is given after the class for
Yeah,
this
that'd be fine.
particular case? Okay.
We're fine with that. I think that's it, Judge. That should be everything.
All right. So Ms. Fuller, can you submit that to me? You
I
can
will, Judge.
send it in Word because I'll probably have to clean some stuff up.
Perfect. I will. Thank you, Judge.
When would you do that?
If I'm going on leave for like a week, so I'm trying to get it done today.
Okay, I'll see it. I'll get it today then. Thank you.
Perfect. Thank you, Judge.
All right.
And one more thing, Your Honor, before I go, as far as the child support being written in the parenting plan, will Mr. Smith be responsible for paying his arrears because he is behind in child support?
Now, so the arrears things, you're going to deal with that in Clayton County, right? So all of the thing I'm
Okay.
going to indicate that he's to pay it. Now, if this point forward, he didn't pay it, you could come back to me and go, he didn't pay it, even though he has an issue in Clayton County, because I'm going to
Okay.
make that a part of my order, which means he has to pay it. So
Yes,
you
ma'am.
have two options. You could go back to Clayton and make them find a contempt on him, or you could come to me as an individual and ask me to find contempt on him. But on the arrearage piece itself, that's you got to do through Clayton County.
Yes, ma'am.
All right.
Okay. Thank you, Your Honor.
All right.
Thank you,
All
Judge.
right, so let me get some background information so we can start on the issues dealing with the house. Looks like Ms. Henderson is indicating that she has some sort of equitable interest in the house. Mr. Hart, you indicated that you had the house prior to marriage. Is that right?
Yes, ma'am.
When did you buy the house?
I bought the house on June 14th, 2017,
When did you marry?
July 1st,
July 1st, what?
2017.
Okay. Did you buy the house in anticipation of the marriage?
Yeah. Yes, ma'am.
Okay. So she's been in the house basically as long as you've been in the house, minus 2 weeks.
No.
No, ma'am.
Y'all moved in together.
Yes, ma'am.
Okay. Yeah. All right. Let's hear it. Ms. Henderson, you may proceed.
Yes, we purchased the home before the wedding. We closed on it actually before the wedding took place. But the whole
Say that one more time
initial-
now. Say that one more
I
time.
said we were in the process of purchasing the home before our actual wedding date. Donovan picked the wedding date. We got the house, we found the house before our actual wedding date because we wasn't planning on necessarily moving before the wedding date, but we were able to close before.
So you
our
all
actual
look for the
wedding.
house together because the intent
Yes, ma'am.
is going to be your marital home.
Yes, ma'am. Yes. And so I paid for all the credit things that need to be done on the credit report for Donovan and everything. And the realtor said it was best to just run with him because he had W-2 income as opposed to my 1099 income. And that's how it ended up only being in his name. But as far as the down payment and closing costs that came from my 401k, everything with the house, as far as the maintenance,
Now, the
lawn
401k,
care.
how much did you pay towards the house? The 401k.
Donovan has all the paperwork because he took all the documents. But it was 5,000 and what's the number on the paperwork? He has the paperwork, but it was over 5,000.
Your Honor.
Okay,
Your Honor.
Mr. Hart, you'll get a chance to speak.
Okay.
So your position is the 401k, you paid $5,000 on it.
Yes, ma'am.
All right. And what else did you said you paid for the credit stuff? What was that total?
Oh my God, I can't remember. It was 500, I believe, for the lady to actually do the credit. But the items that were on the credit was, I'm not really sure, but I know it's a $500 fee that I had to pay her to actually start on the credit files.
So she was trying to get your credit number up.
Yes, ma'am.
All right. Or get Donovan's credit number
Yes,
up.
ma'am.
Okay.
Yes.
And so once you pay the $5,000, how much is the monthly note?
At the time, I think it was $1,387.
And out of the $1,387, how much was paid by you and how much was paid by Mr. Hart?
Donovan was giving me $500 a week. But out of that it was $2,000 a month. And out of that, he had an $800 truck note, his cell phone bill, and his car insurance. So whatever was left out of that, I applied the rest toward the mortgage.
Okay, so he gave you $2,000 a month.
Yes, ma'am.
And you had to pay his $800 truck note.
Yes, his car insurance, his truck
How much was
insurance.
the car insurance?
I think his portion was 203 time. And then his cell phone bill.
Which is what?
His cell phone bill was, I think it was 75.
Okay, so basically you paid $1,000 towards his bill and $1,000 on the house note?
Yes.
Okay.
Whatever was. So, and I took care of everything else.
And you took care of what, like grocery, light bill, water bill, all that kind of stuff?
All that kind of stuff. Yes, ma'am.
Wow.
Okay. So basically you would agree that, and under your understanding, that you all collaboratively took care of the house, each other's bills, no matter, not really looking at the actual number, but that you all collaborated to take care of all the bills, including the house.
Yes, ma'am.
Individual bills.
Yes, and as far as the number, the numerical portion, financially we did. But as far as like lawn care, I had to pay. I was paying for the lawn care. I was paying for the maintenance or whatever was broke, the remodeling. We was remodeling room by room, things of that sort. Donovan, I took care of everything, pretty much.
Okay. So at some point you leave the house. When is that?
I left I initially moved out January 15th. Yes, ma'am.
January 15th of what?
2023.
Okay. And at that point in time, did you pay any more towards the house?
No.
Okay. And why did you leave in January of 2023?
Because our relationship wasn't getting any better. We had a big fight, and from that, I just couldn't regain any type of relationship with Donovan. We had a real big fight, which I think submitted a video, partially of what had took place. And it was just like all our arguments, and they just continued to escalate. And I just didn't want to live like that anymore. And I asked him to leave, and he left for a few hours and came back and moved downstairs. And he thought living downstairs was going to be the answer as long as we were roommating. And it wasn't okay.
Why wasn't it okay?
Because nothing was getting resolved. We wasn't working on our marriage. Nothing was getting resolved. He even suggested at that point we go to counseling. We went to 2 sessions. And the first session, she was telling me that I had to listen to what he said and accept the fact that he wasn't going to cheat. And I'm trying to tell her he said that for the last 2 years, he's been saying that, but he's continuously cheating. And we're fighting in lieu of that cheating. And everything just trickled from there. Nothing was getting better. Lies were being told, and we was just going at it. There was no communication, no.
Now, how are you going at it if you're in the basement and you're upstairs? How do y'all
Because he's upstairs. He could come upstairs and we just wasn't communicating. But even like when he moved downstairs, he still felt the need to roam upstairs. He could come in when he wanted to and just do what he wanted to do.
Okay. All right. And what about children?
We don't have any children together.
Okay. And do you know what the house is worth now?
What it's worth, I think the last I checked, it was at 307.
And how much did you pay for it?
187.
All right. So you're thinking there's about $220,000 in equity?
Give or take. It was somewhere. I can't remember the exact numbers, but yes, ma'am.
How much of that equity do you want?
I want half because he even agreed to give me half. He had initially agreed to let me have the house. He signed a letter, had his dad to sign it as a witness, saying that he would give it to me as long as I didn't ask him for 1 cent. And I submitted that to you as well. But then when he realized that I wanted the house and that was his way of hurting me, he didn't want to give it to me.
Wait a minute. You have a letter indicating he was going to give the house?
Yes, ma'am. He signed it and he had his dad to sign it as a witness. Yes, ma'am.
It wasn't notarized, ma'am.
Ma'am, Mr. Hart, you have a chance to speak.
Okay.
Is that a part of the evidence that you've already given me?
Yes, ma'am.
All right. Ms. Marshall, can you send that to me? All right.
Yes, ma'am.
And so then at some point, your position is that he said he didn't want to give the house to you.
He didn't want to give it to me. He started saying he had spoke to lawyers and he said, yes, because I left, I don't have rights to this and this. He spoke to somebody who was giving him advice. So he went from there and we just never, like I said, that's all we argued about for this past year. That's all we've been arguing about. We still haven't been able to talk about our marriage or none of that and trying to reconcile or anything like that. And then just recently he, I had forgot my thought, but yeah, he had gave me the letter. And then he said I could buy him out and stuff like that. But then he said, he just not gonna give it to me. Because I've asked him a few times throughout the year.
Okay. Mr. Hart.
Yes, ma'am.
All right. So let's start with the house. So based on June, what I hear so far is June 14th of 2017 is when you bought the house. Is that right?
Yes, ma'am. Yes, ma'am. I bought the house on June 14th. Me and Tappy were basically we was basically in a close relationship. We was like best friend. And basically when she heard that I was trying to buy my house, she gifted me some money to help me. I even have documents and paperwork that she did gift me money. I have Wiseman attorney at law. She was there posing as my sister because it wasn't even an intent for her to even try to pursue anything after the house.
Okay, so you're telling me that you all were just in a best friend relationship when you bought the house?
Yes, ma'am. We was in the process, after once she did that, I was like, wow, she really cared for me. And so therefore I proposed to her and married to her, I proposed to her after that. And we got married on July 1st. So
you were not looking for a house because you were going to marry her. You were looking for your own house. You had a good relationship with her. But when she offered to pay for your house, you decided to marry her.
No, I didn't offer. No, this wasn't the case. When she gave me the money, we had already been in a relationship. And then when she gave me the money, I was like, okay, she really here for me. And I figured that since she hadn't looked out for me moving in with her, because while I was staying with her, I was in the process of looking for me a house. While I was staying with her at first. And I was in the process of getting a house. And so she gave me the money and she gifted me as a sister. She gifted me the money. I have my paperwork. And
I understand the gift part. You don't need to give me paperwork for the gift card because you both agree she gifted you money. So you agree she gifted you money. She agreed she gifted you money. So I don't need proof of that because you both, that's not in contention. You both agree on that. What I'm trying to figure out is the relationship at the time of the gift. Your position is you were best friends, and that
Yes, yes, ma'am. We was friends at the time, because that's why
right, you were friends
Yes,
at
ma'am.
the time, and only because she gifted you the money that you decided you were going to marry her.
No, ma'am, this was not the case.
Okay,
You know,
so
I was already having feelings. I was already having feelings for her. I was already having intent to marry her anyway. But see, being that I was trying to provide, being that I was staying with her, I figured I was just gonna get a house anyway, and I would figure that she was gonna move in with me.
Okay,
as opposed to us getting
so
married.
you already anticipated her moving in with you in this house.
Yes.
Oh, okay. Well, that's what she just said. I thought okay. I don't think you're saying anything differently. Do you see something differently from what she said, which was that you all were looking for a house and that you intended?
I was looking for the house.
But you intended for her.
I did all the I did all the footwork and everything else, ma'am. I went to the lawyer's office, did the closing and everything else, ma'am.
Yeah,
I did all the footwork.
Mr. Hart, I need for you so that you're not inconsistent. Listen to what I'm asking you, okay? When you look for this house, was it your intent to bring in Miss Henderson as your bride?
Yes, ma'am.
That's all. I think that's what you're saying. And I think she's saying the same thing. It's just that you're articulating a little bit differently. You're saying she's your best friend. She's thinking she's your fiance. Okay. So maybe it's a little difference on with regard to the idea of it, but your intent was to bring your bride into this house, right?
Yes.
Okay. You said that she gave you $5,000?
I don't think it was quite $5,000, ma'am. I'm gonna have to go to my paperwork. I have my paperwork right here.
All right. What do you think it was?
More like $3,000.
Okay. Whatever it was the down payment that you needed to get into the house.
Right here, $3,124.
Okay. And was that what you needed to get into the house?
Yes, ma'am.
Did you put any extra money on that?
Yes, ma'am. We collectively put money in together, ma'am, because we were staying together.
All
and
right.
as far as the
how much money did you put in?
Half of what she did, because I was giving her money when we were staying together. I was giving her money for this house. And as far as the mortgage, ma'am, I paid the agreement was for me to pay the mortgage.
Mr. Hart.
Okay.
Before we get to the mortgage, how much money of the down payment was yours?
Hold on, hold on 1 second, ma'am. $1,562.
So she gave you $3,100 and you put in $1,500.
She didn't give me 31. We collectively put the money in together, ma'am.
Okay, I'm confused. So the $3,100 that you just indicated was the down payment was not the money she put in.
What I'm saying, because see, I needed, being how my credit was, so however she fixed it, that's how I don't know how she fixed it, ma'am, because we went through a whole bunch of homeboys and friends, credit repair program type things. So however she fixed it, that's how she fixed it. I'm not aware of how she fixed it.
So she was intricately involved in
my credit, in the credit process.
So you're not sure how much money you put down? Look at your papers.
Well, what? Okay, up front is $3,124, and I was giving her money on that. So whatever money she took out, ma'am, that's what she took out. And for what I'm looking at, that's how much we put collectively together down on the payment. And when the lawyer,
how much of money of that was her money?
Half of it.
Okay, so she put whatever it was down payment, whatever the down payment of it was, half it was hers and half it was yours.
Yes, ma'am.
Okay, that's what we're asking. That's what I'm trying to figure out. Okay, so half and half. All right. And then she indicates that she took money from her 401k. Were you aware of that?
No, ma'am, I was not aware of that.
You're not aware. Okay.
And from what I understand, when I was trying to take money from my 401k, you have to initially have proof and documents showing that you're trying to purchase a home in your name. But what my understanding is, because I was trying to get my house remodeled, and that's what they explained to me. So
Okay,
I'm trying to figure out how was she able to take 401k.
We're not going to worry about whether it's what your understanding of 401ks are, because we recognize there are 1,000 different programs and people require different things. So
okay,
I'm not going to deal with that. But only her position is that she used her 401k. Your position is you were not aware that she used the 401k.
No, ma'am.
Okay. But you do recognize she paid for whatever it was, she paid for half, and she fixed,
yes, ma'am.
And she also fixed your credit.
Yes, ma'am.
Okay. Now you're in the house and she says that the house note is $1,387.
I paid every month of that. The agreement was, Judge Barry, was I paid the mortgage and she paid the utility bills.
Okay.
Whatever bill that's what the agreement was. And that's the money I was giving to her every month. And Tabitha kept adding different bills on top of bills. That's how my credit wound up getting messed up, because she kept getting different things added onto my credit and canceling. Just like I was trying to tell her one time not to get a house in Clayton County.
Mr. Hart, I'm not dealing with all of that, okay? Questions are very simple. 1387 was the note that you all paid every month.
I paid that, Judge Barry.
Okay.
She didn't pay nothing of that.
Okay.
I have records of that too.
Mr. Hart, you just said, I'm repeating you. You said that's what I gave Miss Henderson to pay the note. So is she paying the note or not?
Well, when she left, I was behind the money. She left me with bills
Paid
to
the
pay.
note, Mr. Harp, or not? Was Miss Henderson responsible for paying the note?
Yes, ma'am. She was responsible for paying the note.
Okay. And your position is, though, that you paid the house note. That
Yes,
you paid
ma'am.
the money to pay the house note.
Yes, ma'am.
And then she would pay all the other bills.
Yes, ma'am.
Okay. So collectively, you all were living in a household wherein all of your funds were going together to pay all of the notes and bills of the house.
Yes, ma'am.
Did you say to Miss Henderson, I'm giving you money for this house note. I don't want you to put any money on this house note because this house is mine.
Could you come again? I didn't understand what
Did
you're
you
saying.
tell her that you were paying the house note because you don't want her to have any responsibility related to the house? That is, I'm trying to make sure you understand that this is my property and I don't want you to even think you have any interest in this house.
Well, this particularly came from her mouth all the time. Like, this is your house and you paid. It wasn't me. So yeah, if
No,
I didn't say that, she was
I'm
saying.
asking you what you said to her. I'm asking you, did you make it clear that this property was yours and you don't anticipate her doing anything related to this property?
No, ma'am.
Okay. So at some point you would give her how much money per month?
Sometimes, ma'am, it started from like $650 a month, and then it kept going up and down when she wanted to like venture out to do different business and stuff around, like a daycare or anything. This when she'll try to get more money out of me. So for me to pay the
I'm not asking you more
bills.
money about her daycare. I'm asking you, how much money did you give her towards the note?
It started off like $650 a week, and then it went down, and then it went back up.
Okay. Did you have an $800 note for your car?
Not at first. I got my truck later on down the line. My original car note was $500.
All right. And then how much was your insurance?
I'm not for sure because she was responsible for paying the utility bills. She knows that.
Utility bills included the insurance?
Yes, ma'am. Because we were both on the same insurance, and they made our insurance premium cheaper because we both had good driving records.
Okay. And then $75 that was paid for your phone. Who paid the phone bill? Was she responsible for paying the phone?
I was paying my own phone bill.
Okay.
I was paying my own phone bill. And what happened? I was paying my own phone bill, and she decided for us to go on a family plan together. Us and her two kids, all of us going on the same plan together, and all four of us were splitting the bill down collectively.
Who would pay for the light bill?
She paid the utility bill. She paid the light bill and the gas bill up until she
lawn
moved out.
care? Did she pay for lawn care?
No, I did that.
You paid for the lawn care?
Yes, ma'am.
So you were giving her money and also paying separate things out of your
Yes,
own.
ma'am, I was. Yes, ma'am, I was.
Okay. So when you give her the money, are you giving her money in cash or are you sending it through her account?
I'm giving her money in cash, sending it to Cash App and through Zelle.
So when you get paid at the end of the week, you're going to give her $650, anywhere from $500 to $650. And how are you going to get it?
Transfer. We had a joint account together, and I just transferred from my account to the joint account.
Was it an amount that transferred every single week, or was it something you?
It was going up and down because when she wanted to do different things.
I didn't ask you if it was going up and down. I asked you, was it a manual or was it an amount that you had to do every single time at the end of the week, or did it automatically pull that money?
It was manual upon what she asked for.
Okay, and so you would put the money into her account at the end of every week.
In the joint account, yes, ma'am.
Okay. Why not just pay the note yourself if you wanted to make sure that the note was handled without it being considered a gift of the marriage?
Because Judge Barry, I've been through a lot of different situations in my life, and I have been in situations where I have not paid a bill. And my thing is what I told Tabitha: if it was left up to me, things would be behind. So I felt that I felt like I was trusting her to make sure the bills was paid on time. Because, like I said, I done been a victim before. I done had my lights cut off and gas cut off. So by me giving her the money, therefore I won't have nothing. I'm basically old school. How our grandparents did, our grandmother, how granddad used to give grandmama their money, and that's how I was trying to go out. How I seen my granddad did my grandmother.
So basically, the problem though is that you're taking your money, which is says your individual money to pay an individual bill, mixing it with the family bill and spit it back out and claiming that it's still your money. You see what the problem is?
Well, once she paid a bill, I never said anything about that it was my money because the bills were paid and I didn't have anything else to worry about.
That's my point. My point is that it was your marital money.
Okay.
Because it's coming from your work check, right?
Yes, ma'am.
She says that at some point you all can't get along and you go to the basement, she goes upstairs. Is that right?
Okay, for that concern, ma'am, before she moved out, I had literally just took her on a trip for her birthday in October.
That's not my question, Mr. Hart. Mr. Hart, my question is, when you were in the house, who lived downstairs, who lived upstairs? That's my question.
She lived upstairs and I moved downstairs to keep her from trying to move out because I was trying to mend things out with her.
Okay, tell me about
Oh, okay. She was living upstairs and I was living downstairs trying to mend things out with her. I had just got my CDL, started driving tractor. And I was telling her, to keep from arguing, how about if you feel like you didn't want to be around me and if you until we get a divorce and so that being separated, you stay upstairs, I'm downstairs. I had moved downstairs. And before then, she had already had planned, got her apartment and everything. She waited up until I went to Las Vegas with my cousin while I was on vacation. She knew it was a guy's trip. When I came back, her daddy, Robert Bogan, called and told me that she was moving everything out the house. And he was like, that's not right because we have not even went to court or anything, got a separation and everything. She moved out the house and basically took everything. Only thing she left in the house was a sofa, the TV in my bedroom, and a bed and a sofa chair. My mother had to basically help me replace everything in this house. Not only that, she took all of this. I have my handicapped daddy staying with me. And if we need to, I'm willing to call her daddy, Robert Bogan. And he called and told me that that's what she was doing in Vegas. Cause I was in Vegas, my cousin around me, and my little brother was around me. Saying that's what she was doing because it was not right. Because we haven't even went to court yet to even get a separation. And she know that's the truth. She know that's the truth.
That ain't nowhere near no
Okay,
truth.
No. All right.
So
the relationship didn't work out. And she says she leaves the house on January 15, 2023.
No, she left the house in December. She
December.
got her
I
lease.
did not.
She got her lease.
Ms. Anderson, put yourself on mute.
I'm sorry. Okay.
She signed her
So
lease.
you said December of 2022?
Yes, ma'am. She signed her lease in December. She was in the process of moving things in and out the house, but she kept trying to, after she moved out the house, she kept trying to keep coming over here. Instead of her moving everything out the house, she would just come over here every other week trying to move something out the house. And, and it got to the point, we had to call the police, like, wow. The police had to tell her, did she move everything out the house? You can't keep coming over here like that, keep trying to get everything out the house. She signed her lease in December. And then when she signed her lease, she was first she left and went to her sister's house. And then after she left and went to her sister's house, that's when she got an apartment because that's when she signed her lease in December. I wish I could send you the email.
Take a seat. You're making me dizzy.
Because I can't believe she did this, Miss Bear. She went to the courthouse and told you all that she wasn't even trying to see nothing from me. Let's take my house.
Mr. Hart, what is she trying to do?
She's trying to take my house from me.
Mr. Hart,
she told me she got everything she wanted from me.
The house. Tell me, let's go to this letter. Did she?
We worked everything out after that letter.
Mr. Hart, when was this letter signed?
Before everything was started. This letter was signed, wasn't even notarized. She took it upon herself to notarize her own thing, and I told her that was illegal.
I'm not even worried about her notarizing it. I'm asking you, is this your letter and is this your signature? Notarizing only becomes an issue if you claim it ain't yours. Did you write this letter?
Yes, ma'am.
Why did you write it?
because at the time we was in an argument and she kept trying to make me feel bad about it. Things talking about why would I want to leave? And if I love her and all this other stuff, I would leave. And I thought about it. I have my handicapped daddy here. I cannot leave my handicapped daddy here.
So why did you give her the house if you can't leave your handicapped daddy here?
I did not give her the house. Like I said, we was having an argument, Judge Bell. We were having an argument. And just out of emotion, I said, here you can have the house. But she knew then that's when she said, your daddy gonna have to find somewhere to stay. And I'm like, I can't find a way for my daddy to stay. He's handicapped, disabled, and old.
This says today, October 16th, I leave this house, 6510 Carriage Lane, Stone Mountain, Georgia, to Tabitha Henderson. This is my consent and confirmation, and I will transfer the deed over to her within the next 30 days. I'm in my sane and right mind, and this is my decision. I will pay nothing, no bills either. And then you signed it, she signed it, you dated, and looks like there's a witness. How is it? After that, Judge Bear, we hadn't started working our relationship. I understand.
After that,
there's nothing that takes away this document. What takes it away? Did you all agree separately that the house would now go back to you? And
yes, because when she signed the paperwork, Judge Barrett, she clearly said that she didn't want nothing. When she went to the house, what that paper? I have the paper. When she went to the courthouse, she clearly said she didn't want nothing from me. She has everything that she wanted. Matter of fact, I can share that document to you. Because after that, yes, ma'am, we had agreed that I keep the house.
Okay.
How
did y'all agree that you keep the house?
We agreed it verbally, and then when she went down to the courthouse, Judge Barrett, this is what she said. She said the defendant and I have already divided our marital property, and we are both satisfied with the division. She does not. I'm not seeking anything else from me.
That's not what that says, Mr. Hart. It says, I'm not seeking alimony, but it says that we've already agreed to what I'm going to get. And the letter is what you agreed to.
And she took everything what she got when she left here. She left me with nothing but the house and a sofa, a TV, and a bed. She took everything. That was the purpose of her saying that she got everything she wanted.
I can't agree with that, because you have a document wherein you indicated you gave her the house. And then she signed a document saying that she's gotten everything that she wanted, which would make sense because she has the letter that you gave her the house.
But she moved out, Judge. She moved out.
She doesn't have to live in the house to take ownership of a house.
Yes, ma'am, I understand.
You might have in distress signed this document, but it is a signed document. And you're not contesting that that's your signature. It doesn't have to be notarized. It was witnessed. So, I mean, I noticed that she must be a notary and notarized it, but that notary is not, that doesn't make the document invalid because you didn't need a notary in the first place. You only need a notary on certain particular things, but this document kind of says what it says, which is you intended to give her the house. Mr. Hart, when you gave her the house, when you wrote this document, what were you intending on doing?
I didn't know what I was intending because, like I said, I was upset at the time. And like I said, after that, we had to really work things out, and she agreed. And she even told me out her mouth she didn't want me. She didn't want the house, Judge. I promise. We done went out on, after the fact, we done went on dates, done went out and everything. All of a sudden, she heard about a court date. Now everything, she's switching everything back up. She like being malicious about everything.
She hear about a court date and what happened?
We just recently went out on a date. Trying to rekindle our relationship.
Okay.
We just did it. I have bank records showing that we both went to Dudley's. Pictures and everything.
You both went where?
We went to Dudley's Bar and Grill. We went out on a date to Dudley's Bar and Grill. You know, we just trying to rekindle our relationship. We just went to like a jumping house. We got videos on Facebook about that, both of us spending time together. And it's like, as soon as she heard, because she didn't even know we had a court date until I told her we had a court date. And all of a sudden, now when I told her court date, she's back on trying to take my house from me. And when she clearly said she didn't want to take it from me. Then when I asked her, I said, Tabitha, I thought you said you didn't want the house from me. She said, say, Donovan, I said a lot of things. I can go back and change my mind on it. Like, why are you doing this to me? I've been trying to work on a relationship and rekindle things with Tabitha all for the time she been gone. I've been trying to talk to her. And she feel like she could just cuss me out, snap on me, and feel like I shouldn't feel no type of way or say anything about that. I just got to be quiet, and that's what I've been doing. She was just recently. We just recently talking about going to Bermuda together on my birthday. My birthday.
When is your birthday?
June 23rd next month. We just talking about it now being that we in court, she trying to deny and trying to act like she didn't say none of these things. And when I'm telling you,
Hey, who was that?
You keep calling me names. You keep calling me names.
Where's that?
No, that's a video I submitted.
Oh, is that me?
no, she's playing a video of an argument that we had a while ago.
I'm
That her son
sorry.
recorded.
Am I playing that might be me. Yes, that might be me. I was looking at your evidence. I may have. Kalia, can you come show me how to cut it off? I was going through your evidence. I must have clicked on it. So that might have been me. Ooh, how do I stop that? I think I clicked on it. Minimize. Okay. Oh, no, I opened it here. Oh, okay, so that's media. Okay, click that off. Okay, sorry, I apologize. I didn't know that was me. I was like, where's that coming from? Okay, I was going back through the
Judge Barrett, and like I told her, you know,
if she, I'm gonna send it to you, Miss Harris. Can you separate the issues dealing with the adultery? Because there's some pictures in there and some other stuff. Separate that from the other so that I can talk about. I want to take those are some graphic pictures and I don't want to show them on YouTube. The pictures. So let's see if we can separate those pictures.
Okay,
I'm
sorry, Judge.
Not you, Ms. Marshall.
A lot of JPEGs. You want me to look at the JPEG?
You know what? Don't worry about it. I just won't share them. Don't worry about it. I'm not even going to try because I might accidentally share some of these pictures and I don't want them to be shared on YouTube.
Yes, ma'am.
The adultery that you're talking about, Ms. Henderson, initially, is that the impetus for the divorce? Like, is that why y'all started the fights?
That's the ground of it, Your Honor. But aside from him cheating, it's the argument. Like in the video, those are the arguments. That's how it escalates every time. And it's due to his cheating. Yes. And that's how it escalates every time.
Mr. Hart said that you were aware of the cheating and you were trying to reconcile.
I was aware of the cheating, but we were never working. Your Honor, if this man just told you and I left in December, what was we rekindling when he signed the letter in October? I left in January when when I got the lease.
Well, he signed this letter is signed in October 20.
Yes.
October 2020.
The fight occurred after that. And he's saying
what
his stuff he's saying is making sense. But yeah, the adultery was the main cause of when our relationship started going down here.
Did he sign this after you found out about the adultery? Is that why when did you find out about the adultery as it relates to the signing of this letter?
No, I've been new because he was fooling with some other female. This particular incident is one female he was with for fooling with over 2 years. And the fact that he
one that sent the pictures?
Yes, ma'am. So that's the main, she's been there. And I've stayed and tried to work it out. That's what I'm trying to tell him. I've stayed and tried to work it out. 2 years, Your Honor.
You also, there was another, you said it was a woman that was in the house. Who was in the house?
No, she wasn't. I don't know who she was. I don't know who that lady was that was in the house. He gonna try to act like I didn't see it, so it didn't happen. That's how he played that.
Okay. Do you know the lady's name? You don't have to say it on YouTube. But
I don't know that particular lady. No.
The one that sent those pictures. Did she send those pictures to you or did she send those pictures to Mr. Hart?
Yeah, to him, to Mr. Hart.
And you just saw him on his phone?
Yes, on his phone, on his watch. Yes, ma'am.
Did Mr. Hart acknowledge that he knows who that person is?
At first, well, he didn't admit until after I showed him the evidence, because when I came to him and asked him about it, he told me no. He made it seem like I was crazy and I was just hallucinating, like I was just making up stuff. He called me miserable. He said I was just messy. When I found it, I was the one messy. When I actually found the evidence. Mr. Hart put an effort to see that lady. He taking this lady out of town. Mr. Hart has put an effort to be with that lady. And that's why I said it's not going to change. It's not going to stop. You chose to fight with me. And yeah, he knows. So he didn't initially confess the fidelity until after, I think we had our first counseling session. To after that. But before, he wanted to make it seem like I'm just delusional and it's all in my mind.
So the woman that so he admitted the affair in the counseling, but indicated he wanted to get back with you. Were you amenable to that?
The first time we went, yes. The first time I was, yes. And I stayed.
Okay. Did you happen to see these pictures and these text messages, Mr. Hart, that she presented to the court?
I just seen these text messages when the court that was coming up. I guess Miss Marshall told her to email the things to me. That was the first time I have knowledge of those pictures.
The girl in the pictures and these pictures, you're saying that you've never seen that girl or these pictures?
I never said I didn't never see the girl in the picture. There was a girl that, I did step out on my wife, and like I said, we talked about that. We worked past that, and she got a phone call. Okay, I have a friend that has like a delusional wife, and Tabitha knows that. I guess my friend must have ran and got into it with his wife, and his wife like don't know me or Tabitha from Adam or Eve. She decided to call Tabitha on Facebook, trying to get back at her husband of my friend. Started telling a whole bunch of stuff that had already happened that Tabitha had already got over. And being that she told Tabitha all this stuff, not only that, she even said that I had another baby on the way. And I'm like, really? And Tabitha already know this stuff, but when she said I had another baby on the way, that just stemmed Tabitha to even just forget about everything we tried to work on. And kind of find out, Tabitha can admit it, kind of find out that the girl was just trying to get back at her husband. And, and that just killed everything that me and her was trying to work on. Because like I said, we was trying to work on our relationship up until that day.
Okay,
when
so
that day
when was
happened,
the first time that Tabitha told you she was out of this relationship? When was it?
After that phone call that my friend wife called her. She was not even thinking about it, and that was like
what date?
Oh my God, that's probably the same day that letter got wrote.
No,
that was probably the same day that letter got wrote.
When was
because
it?
Tabitha came down because the thing was Tabitha came down. I wasn't in the house from work.
I need for you to listen. When was it that you realized your relationship was on the fritz?
Well, I realized my relationship was on the fridge before her birthday, October 6th.
Okay, so in October, that's when you realized that y'all about to start, that she's interested in divorcing.
No, we was like just really talking about separating.
You were talking about separating in October.
Yes, ma'am. Yes, ma'am. And I was trying to take her out of town, to try to rekindle things. I had rented an RV and everything. I took her to Tampa, Florida, trying to rekindle things with her. I took her daughter, and her granddaughter, and her daughter fiance.
So when was it that you believed that Tabitha told you she no longer wanted the house?
Well, she told me she no longer wanted the house, like in November, because we was back together. We went to a Thanksgiving dinner, my mother's birthday, and everything together.
Heart, when did she say it? What did she say? Don't give me generalities, okay? I need to know what were you saying. You had a conversation with her.
Okay, this is the conversation that she said. She said this is what she told me. She said she no longer want the house. She just want to get out of this marriage. She just want a divorce. She said, you got the house, and that's what you so gone hold on about keeping. You can have the house. I just want out the marriage. That's quote unquote what she said. Right or wrong, I'm sorry, but that's what she told me.
Wrong.
Okay.
She said she just want out this marriage. Because like I said, I've been trying to talk to her all year long. And every time I talk to her, it's like I'm coming to her humble as I can, being that she say she hurt. She says she have the rights in the ground to snap on me and cuss me out and just like just be belligerent every time she talked to me. Because she said, can nobody tell her how long she need to be hurt? And I've been trying, that's her main, can nobody tell her how long she can heal or be hurt? And I've been trying my best to do everything I possibly can to try to rekindle this marriage up until this day. And she clearly told me that she didn't want nothing else from me. She took everything to her apartment, that's all she wanted. She said only thing she wanted, she just wanted out this marriage. Now all of a sudden we got a court date coming up. Now she talking about I don't understand it.
So you think she wants out the marriage because she wants the house? No,
I mean, because one minute I'm trying to tell her like, come on, let's work things out, and then she don't know, she don't trust. I'm like, you just got to believe. I don't know. Be honest with you, I know why she wanted the house, because she wanted to open up many different businesses with this house. Because that was like our main argument, because she wanted to open up a daycare, and I'm telling her like, if you open up a daycare in this house, I'm gonna feel very uncomfortable. Then but when I'm telling her I'm gonna feel uncomfortable, she gonna sit down and say I'm not supporting her. I even offer her to go. Boom, Tyler, we can go get a building. Rent a building for your daycare. I'm sorry. No, I don't want to do that. I want to do it in the house.
Information is not gonna that information is not gonna affect the decision. I'm purely looking at.
But that's basically what she wanted the house. She want to open up multiple businesses.
But what I'm asking you, are you saying that she's lying? For what purpose? To get the house to open up the daycare? Is that the reason you're saying she wants?
That's the main reason why she want to open up get the house, because she want to open up a business in this house.
Why she wants the house. I mean, you have a reason you want the house too.
Yes.
You both can have reasons for wanting the house. That's not my question. My question is that you're saying that she's lying about something, and I'm trying to understand what your basis is that she's lying about.
She want to open up a daycare in this house, Your Honor, and I'm telling her
what would be wrong with that.
Because like, if we were staying here together, it's like the rules that she was giving me, the argument that she was giving me, like when I come home from work, I had to be confined in my room. And I feel like if I'm paying the mortgage, if I'm paying over 13.
Do you believe that her desire to open up a daycare caused the demise of the marriage?
No, that's not the reason why. No, that's not what I'm saying, Judge. You
Okay,
asked me.
then why does
You
it?
asked.
Why
You
do I
asked me. You
why do I
asked me
care?
why. You asked me why she wanted a house, and I'm telling you my opinion. The reason why she wanted the house.
Okay, no,
It's not. It's not.
that's not kind of what I was trying to say. I thought you were arguing that there was some lies that she was telling about the house that affected the divorce.
Oh no, nothing about the house affect divorce. It's just our relationship. That's what affect the divorce. I just took upon when you asked me, why do I think she want the house, and I'm just telling you what I think. When you asked me that question, I was just telling you what I think. The reason why I think she want the house.
Okay.
Because of the arguments we had.
Okay. Do you think that she is through with this marriage?
To be honest with you, Judge, off and on, because I just had a conversation with her on yesterday, to be exact. She said, well, we get a divorce and then we start back dating. I have to date her and everything else. And I got my right hand. We can both put our right hand up right now.
God. Like, why would I? Oh,
Okay,
We
boy.
both put your right hand up. We both put our right hand up right now. We just had this conversation yesterday.
Put yourself on mute, Ms. Henderson.
We just both had this conversation yesterday. She said, and I was trying to tell her, I was like, why should we get a divorce to start everything back over? Because if we're gonna start everything back over, there's no sense in divorce. And I told her, if we get a divorce, I may not think I want to get married again.
Have you and Miss Henderson had any sexual encounters?
No, ma'am. She been at her house and I've been over here for like the year, but we have been seeing each other.
Okay, but y'all have not been sexual.
No, ma'am.
All right, then generally that means that the marriage is irretrievably broken. Okay. Is there any hope for reconciliation, Mr. Hart?
Well, at this point, no, ma'am.
Ms. Henderson, is there any hope for reconciliation?
No, ma'am.
Okay, now let me go back one more time for the house, just to make sure I understand the position. Is it your position that you want the court to consider this letter and that you get the entire house, or do you want to split the house?
No, the entire house. How would we split? No, the entire house, Your Honor.
Well, you would buy him out?
If have to be, I don't know how.
You would buy 50% of the house, you would buy him out, or you would sell the house and then you would split the money.
Okay. You went.
I'm asking you, what is your wish? You want the court to consider? Because I mean, I'm going to look into the letter and see if the letter in and of itself is sufficient. And my question to you is, his position is when he gave the house, he was distraught, and you are aware he was distraught, and that he should get 50-50 of the house. Is that your position?
No, Your Honor, but if that's an option, we can go with it. Because he did say at one point he would sell it and we would split the money. He did say that at one point. But no, he was not distraught. He was in his mind and he got his daddy to sign it. Like, Your Honor. So
Okay.
yes.
So you want the house?
Yes.
All right. So I'm going to take a look at the letter and I'll look at the law to see if that letter is sufficient to transfer the house. I do think that this is marital property. I think Mr. Hart had it, but he gifted the house to the marriage. It's very clear he did so because you were involved from the beginning, from the credit down to the deposit, down to the paying the house note. That house note came out of marital funds. It was paid by you each and every month out of a marital pot. It is a marital home, which means generally on a marital home, I would split it 50-50. But I do have a letter where Mr. Hart says that all of it is Ms. Henderson's. So I'll take a look to see what the law says about that letter and if it's sufficient. If it's sufficient, the court will follow the letter. If it's not, I'll split the house 50-50.
Yes, ma'am.
Oh, one more thing, Mr. Hart. I would generally start splitting the house 50-50, but when there's allegations of adultery, the court can move that needle towards Ms. Henderson. In other words, let's assume I was going to split the house 50-50, but Ms. Henderson is able to show that she went through heartbreak as a result of adultery and things that you did to her as related to women and other things. The court can move that needle a little bit towards the right. When Ms. Henderson first asked the court, I asked Ms. Henderson how she wanted to be divorced, whether she wanted the divorce on the grounds of the adultery or something else. She said something else because she thought it was going to be easier and we thought we were going to be done. But then she said, no, I got to fight over the house. So therefore, I didn't look at the evidence. I have now reviewed that evidence. Ms. Henderson, do you want the court to consider adultery so that the court would consider funds in the marriage, or do you want the court to keep it on the fact that the marriage is irretrievably broken?
To consider the adultery.
All right. In the consideration of the adultery, you sent me some pictures and some text messages. You're gonna have to go take me through it.
Yes.
All right. What you have to take me through the adultery.
About the pictures?
Mm-hmm. The pictures or whatever evidence that you think you have of the adultery.
Yes, I submitted the pictures and that was the the ongoing relationship that he had with this one particular female.
Now, how do you
But
know
I
it's an
also
ongoing relationship? You only submitted this one text chain.
Mhm. And it's another photo in there with him texting another female, a separate female as well.
Let's just
I
deal
think
with the first female, one female at a time.
okay. So what do you want details about the
Yeah,
adultery?
how do you know that this was a long relationship? I mean, I see the photographs and things, but someone could send the photographs accidentally. I don't
Oh
know.
no, okay.
How do you know?
Because before, now this is the thing. When I first found out, the text messages it was coming via text messaging. And I talked to him about about the adultery, and he was denying it, and he was saying, he would end it and things of that sort. Once I found out, and then it became that. And then, okay, so when I checked his phone again, it wasn't there. Then he started texting through email. He started emailing her. So they're going back and forth because she knows about me. And even if you read one of the things she asked, is he afraid to leave? Because I think she said about hurting me or something like that. Is he afraid to leave? So he's indicating to her that he's going to leave me to be with her, and things of that sort. And I've
He's
asked
gonna
him,
leave you to be with her. Where is that?
yeah, if you read it on one of the text messages on one of the evidence I submitted, yeah, she's asking him, I know if that's why you're afraid to leave her because feeling guilty or something to that extent.
Oh, hold on, let me
And
see.
I asked, okay.
Oh, I see it. And I feel like you feel guilty for leaving an old girl because she has given you everything. So you don't want to seem like you were using her. I feel that's what took me so long to leave her, but it's over. I finally left and I ain't going back. I've been here at my grandma's.
Yes. So it's like no matter how many times he told me he ended it with her, he continued a relationship with her. He was giving her money, he took her on trips, and he just was, just verbally mean to me.
So, Miss Reed, do you work?
I'm not currently.
Okay.
I'm in the
Are you
process of looking
disabled?
for a job. Yes, I'm looking.
But are you disabled?
No, well, I have health issues, but it haven't prevented me. I've just been looking. I haven't found a job yet.
Okay. Ms. Davis, do you mind going back and imputing 1252 as the income for the gross monthly? I always imputed income on parties who have the ability to work. You got to have, I wouldn't impute an income there. And Ms. Green, where do you work?
Hormel Foods as an electrician.
Electrician. And $85, is that the health insurance through your job?
Yes.
Okay. Is that $85 what you pay for your total family or just for the child?
Actually, it's a family plan, and $59 a week come out of my check.
And the family plan is for you and the child?
Me, the child, and also it was her as well.
Okay.
And Your Honor, what imputed income did you say you wanted me to use for her monthly?
1252.
Oh, okay.
Where did the 85 come from?
It was the 59 a week divided by 3 times 52 divided by 12. So because she said that the insurance covered all 3 of them, I divided it by 3 for approximately what the child's portion would be.
But the family plan, Ms. Reed, if Ms. Green, if Ms. Reed was not on the plan, would it still be considered a family plan with you and the child?
I think I have an option to put myself and child.
Would that be less? And how much would that be?
I'm not sure. It would be less, but I'm not sure how much less. I had to look at my benefit plan from my insurance.
Okay.
I've finished adding her imputed income.
Okay, what's that number?
Do you mind if I share my screen?
Yes. Okay, so the amount of child support is $857. Did y'all want to agree to make it $964, or do you want to keep it at the number $857?
$964 is fine.
Okay, so then if you would, let's do a upward deviation of $100.
So Your Honor, are we going to need to read to the forms, or do you want me to just go ahead and make it 964 even with the deviation?
Make it so that it'll be the same.
Okay.
Yeah. All the documents that you reviewed, Ms. Green, are they to your satisfaction?
Yes.
And Ms. Reed, all the documents that were presented by Media Davis is to your satisfaction?
Yes.
Is it your position, Ms. Green, that the marriage is irretrievably broken with no hope for reconciliation?
Yes.
Is it your position likewise, Ms. Reed?
Yes.
All right, so you have a 12-year-old that you have guardianship over, and you've already made agreements regarding visitation and child support to your satisfaction, Ms. Green,
Yes.
Ms. Reed?
Yes.
All right, so I'm gonna adopt those documents, and then you'll receive the divorce decree in the mail with these documents that you've already signed and reviewed as well. Do not do anything inconsistent until you receive a copy of these documents, okay?
Okay.
All right, thank you so much. Y'all are free to leave.
Thank you.
Mhm.
Miss Davis, the mediator, I'm sorry, Judge. Did she
Yeah,
send
she's still
you?
on. She's still on.
Hi, Miss Davis, I'm sorry. Did you resend those documents? The worksheet?
Only the child support worksheet. Yes.
Yeah,
I
all I
just-
need, that's the only one that's changing. Let me hear from
Perfect.
you,
Yes, ma'am. It just
so I
came
can
through.
see
Thank
what you
you.
think are
All
the
right, great.
issues that we have to resolve.
Yes, Your Honor, if I may share my screen.
Yes, you may.
Thank you. All right, so the first exhibit I have is the consent order that was entered April 26, 2017, in which the defendant was found in willful contempt, owed $17,822 in child support, was ordered to pay arrearages $5,000 in 2 installments. Thereafter, his basic child support obligation of $711 continued. He was ordered to pay $150 per month towards the arrearages. And then he was also ordered to pay $1,500 in child support, in attorney's fees at the rate of $50 per month. The court also ordered an income deduction order. Judge, I know that this was not a private case. This was a DHS case. But my client, because DHS was not enforcing the original order, she hired me to file a contempt. So I was not acting on behalf of DHS, but I was acting on behalf of the custodial parent.
Okay.
We received correspondence from Mrs. Noeline back in August of 2022, alleging that the income deduction order was taking extra money from the client and that it needed to terminate. Mrs. Noeline's calculations in that letter and in the filings were incorrect, as she started her calculations from 2018. This is just for demonstrative purposes, and I'll go back to it. Exhibit R4 is our calculations of the child support obligation, arrearage, and attorney's fees. The child support under the consent order started April 2017. He had a basic obligation of $711. He had an arrearage obligation as stated here. He had an attorney fee obligation as stated as such. And the income deduction order garnished certain amounts. I'm going to quickly move to R5. R5 is a document we obtained from Department of Child Support Services, which provided each of the items that were garnished from Mr. Manzanares' account, and we populated that into our demonstrative evidence. So we put in
That the garnished wages is what you got from R5?
Uh-huh.
Okay.
Yes, Your Honor.
Your Honor, is it possible maybe for the interpreter to speak to the limited English speakers over the phone or something? Because
I forgot.
I'm not getting
I'm
an
sorry. You're
opportunity
right.
to interpret.
We're not doing good. We're not doing good. Okay, let's see.
I can call the parties and then they can listen over the phone, as that way it'll go, much quicker than if we have to stop every few minutes.
Ms. Koski, do you have an iPad or something that your client can get on in another room? Because I think if we can put them on mute and allow her to interpret constantly, it might move a lot faster if there's another device she can get on in another room.
Or even in the same room, that would be fine because they only have to listen. If they can listen to on a cell phone or.
Okay, or if you have a cell phone that she can, but that cell phone might cause interruption.
Okay, well.
Honor, Mr. Manzanares also needs interpretation.
Señor Manzanares,
what we're going to do is.
teléfono celular para escuchar la traducción.
So what we're going to do is that we can put them on mute. They could be on mute, and then she can interpret from them by, well, they still need another device. So if they have on, let's see, how can we do this?
If there's a cell phone for each one of the limited English speakers, I will put myself on mute and they would put themselves on mute, and then I can interpret everything, and we can go back if I need to answer or translate a reply from them.
Mr. Manzanero, do you have a cell phone?
Señor Manzanares, ¿usted tiene un teléfono celular?
Sí.
To do it.
Your Honor, do you need me to start from the beginning? So back in 2017, I took on a contempt action for Mrs. Alarcon, who had a DHS child support order that was not being collected. April 26, 2017, we secured a consent order in which the court found that Mr. Manzanares had $17,822 worth of arrearages. He purged himself from contempt by paying $5,000, as itemized here. Thereafter, he was supposed to continue his child support obligation of $711 and pay an additional $150 per month towards the arrearages. Additionally, my client was granted $1,500 in attorney's fees to be paid at the rate of $50 per month. From that order, we also received an income deduction order, which took place immediately. This is simply for demonstrative purposes, and I'll get back to it in just a few moments. R4 is our spreadsheet. Our spreadsheet itemizes when the obligation became due under the consent order, which started April 2017. Mr. Alarcon was to pay $711 as his current child support.
the purge amounts, which he did, and then continued 150 towards the arrearages, $50 of the attorney's fees. In this column, we gave him credit for everything that has been garnished, which was different than what Ms. Noeline provided us. So what we did is we requested from Child Support Services a ledger of payments that were garnished from his income. I'm going to move down in exhibit number 5. I'm sorry, it's backwards. So the last time he was garnished was July 31st, 2023. That's when he, according to DHR, had fully paid his child support obligation together with the arrearages. DHR does not collect attorney's fees award. So what happened is that Mr. Manzanares was being garnished, but he wasn't making enough from his payroll, and thus he voluntarily made certain payments to Mrs. Alarcon. Those are reflected in the 6th column. Mrs. Noeline provided us with a stack of carbon copies of checks, which purportedly were voluntary additional payments of child support. The final column only has what we were able to find, because they were carbon copies and they were not canceled checks, in Mrs. Alarcon's bank statements, and we gave him credit as such. The child support obligation when the last child aged out ended May 2020. However, Mr. Manzanares still had thousands of dollars worth of arrearages at that time. So the income deduction order continued. The problem arose when Mr. Alarcon didn't pay additional payments through an income deduction order. So when the additional payments, voluntary payments of child support that he made, he should have directed to DHR so he would have gotten credit. Notwithstanding, the income deduction order stopped as of July of 2023. As we stand here today, he has paid, let me go back here. He was supposed to pay $17,822 in arrearages, $2,708 in child support obligations, and $1,500 in attorney's fees. The total would have been $46,340. He paid through garnishment $4,362.31, which Mrs. Noeline did not account for the $1.50 charge per garnished payment. And then we gave him credit for $3,533 worth of voluntary payments that he made on his own. Mrs. Noeline, in her pleadings, had over $7,000 worth of carbon copy checks, but we could not find those in the extensive search that we did in R6, which we went back to Mrs. Alarcon's bank statements to compare the deposits because Mrs. Alarcon was mobilely deposit each of the checks. So we could only provide Mr. Manzanares with $3,533.62 worth of voluntary payments. Thus, there is an overage paid of $6,593. These are all voluntary payments that he made. So under the law, the child support order and garnishment terminates by operation of law when the obligation is satisfied through DHR. If we go back to R5, the last time DHR garnished Mr. Manzanares was July 31st, 2023. They have no reason to continue to garnish him because his obligation has been satisfied with DHR. If Mrs. Noeline wants a order terminating, even if a new IDO was presented, DHR couldn't garnish him. So where did it go wrong? It went wrong in that Mr. Manzanares did all of these overpayments, and the ones we could give him credit for. However, he should have been making overpayments through DHR so that DHR could properly allocate those to the arrearages. We have no opposition. If there needs to be an order to terminate, we haven't had any garnishment since 2023. When we received the letter in 2022, there was still, if we look at our chart, there was still outstanding arrearages amount. The child support obligation had terminated, but there was still, so we could not consent to the termination. Finally, if the court finds that the $3,000 were in overpayments, we have case law that supports that any voluntarily overpayments of child support without the consent of the custodial parent, the non-custodial parent does not get a credit for. I have a 1990 case. I further have a very recent 2023 case out of DeKalb County where the VA made a mistake and it just created a mess on child support. But if you go down to the bottom, the court cites that the general rule is that non-custodial parent has no right to credit to voluntary overpayments of child support without the consent of the custodial parent. And I finally have yet another case, another very old case that's still good law. So Judge, our position is that any voluntary overpayments were Mr. Manzanares doing, he could have gone to DHR and sought to terminate, but he's not being garnished, and there's no case law that supports a reimbursement of the $3,000 that we allege he needs to be credited for.
All right, thank you. Ms. Noel.
I'm going to stop sharing my screen, Your Honor.
Yes.
So I agree with about 80% of what Ms. Kosky has stated. So the procedural history is correct. 2017, Mr. Manzanares was ordered to pay $17,822 in arrears. He made a $5,000 purge payment immediately by making direct payment to Ms. Koski's office. By 2022, the payments
So
that
he
Mr.
went in August of 2022 and said, hey, I want to show you all these voluntary payments so that you can credit it towards my arrearage.
It was prior to August 22. That is when we contacted Ms. Koski's office after his attempts were not successful with the child support office.
And why were they not successful at the child support office?
Your Honor, I don't know. I cannot speak for the child support office. But Ms. Koski has told me the same
Did
thing.
you ever
that-
contact the child support office to see what the issues were and whether it could be resolved?
I did not, Your Honor, but Ms. Koski told me the same thing, that her client went to the child support office to try to fix it, but the payments are still not noted on his ledger.
Judge, we contacted DHR twice. Initially, when Mrs. Noeling wrote me in 2022, and at that time, the child support arrearages had not been satisfied. And then we contacted child support services in order to prepare for this hearing. And so when
they had not been satisfied by the information that they had on their system.
Well, even with the overpayments, as of August of 2022, he still had arrearages.
Oh, as of August 22, he had arrearages.
Yeah, so that's the confusion. That's
why
what I'm
would
telling
there be a cancellation of the IDO if there are arrearages?
I'm sorry, I didn't hear you, Your Honor.
Why was he asking for to cancel the IDO if there are still arrearages?
Right, and that's why we explained that we were not going to consent to the IDO. We believe there were still arrearages, and DHR would not give credit to the carbon copies of the checks. And so had he provided canceled checks, DHR would have sent a letter to the custodial parent asking for confirmation of additional payments, and then they would have matched those up. But we could not confirm the $7,000 worth of carbon copies. The only thing that we could confirm was $3,533.62 because the carbon copies are not evidence.
And Ms. Dolan, why not make DHS a part of this lawsuit, particularly if you're claiming that, it sounds like you're claiming it's their error?
So, Your Honor, if I can address Ms. Koski's allegations as well.
Okay.
Because according to our calculations, Mr. Manzanares has already paid more than $17,000 extra, and his payments and obligation was already satisfied in 2022.
The problem that we have, sorry, Noeling, I hate to cut you off, but if
But
you
let me,
pull up your letter,
Ms. Koski, I have not been cutting you off. Please don't cut me off. Please,
Go ahead.
I haven't cut you off. So according to our calculations, in 2022 summer, he had already paid all of his child support and all of the arrears. And again, I always try to reach out to opposing counsel to try to talk things through.
I can't hear you.
I said, I always try to see if we can resolve things by agreement, but when we sent this letter to Ms. Koski, I didn't hear anything from Ms. Koski. Ms. Koski never said, I'm sorry, our calculations show that he still owes, or Ms. Alarcon didn't say, no, he doesn't owe. I did not hear from Ms. Koski. It has been radio silence until yesterday when we received the answer. So at no point has Ms. Koski or her client had any type of communications to say, well, your calculation is missing 1,000 or is a year off. There has been zero calculation, and we did our best. We put all of the numbers that we had with the payments. We sent it over. This is the numbers that we had, and there was radio silence after that.
So you wrote her in 2022, and you're saying the first time you spoke to her was yesterday?
Yes, Your Honor, this morning.
Okay.
And she sent an answer yesterday saying that her calculation is incorrect. There was no communication from Ms. Alarcon or Ms. Koski as to our calculations.
Judge, we wrote, first of all, the letter in August of 2022 X's out an entire year. Noeline, if you would put up your letter to show the court, and we have communications in which we immediately responded to Ms. Lynch. So go back down. No, go back up. See, you start what right there. You start your calculations April 2018 through April 2020.
I'm sorry, where are you looking?
In the letter, Your Honor, where it says consent child support, April 2018, right in the middle where the math starts. You see that?
Where it says current child support?
Yeah, right here. The calculations start April 2018 through May 2020. But the obligation started April 2017. And if you go back to my exhibit that you just published. No, not.
I just wanted to point out the calculation started at 2018 across the board. So at 2018, the payments, and this was an oversight. We should have included the 2017 child support and his 2017 payments, which weren't included, which is why this arrearage that we calculated of $1,300 was so low, because we didn't include the 2017.
Well, it could be high too. Depends on what he did in 2017. I mean, if the obligation is high and he didn't pay anything, this number would be higher.
Right, so if you go back,
then of course it would be lower. So not having 2017 could affect it either way. It could go up or it could go down. Just depends.
So if Ms. Noeline goes back to our demonstrative exhibit that she published.
But before you get there, let me, I kind of want to get an idea of the timing of things. So the child support obligation, what year did it actually begin?
It's 2009, if I'm not mistaken. It was
2009.
2008. 2008, I believe, Your Honor.
But in 2017, there was an order. Put that order up, Ms. Koski.
Yes, Your Honor.
I have it here. Here it is.
Okay, go down. Let me see if this is my order. Did I sign this? Okay, that means I
Yes,
need the numbers. Go back to the top. Okay. Oh, were you guys both on this case?
Yes, Your Honor.
Yes, Your Honor.
Okay, y'all were both on it. Okay. Go down just a tad bit. Okay. No, I'm sorry. Go back up to the top. All right, stop right there. Okay. Now that's 17,822. When I did that 17,822, was that numbers you brought to me, or did I calculate those numbers? Do you
We
recall?
did, Your Honor. It was a consent.
You brought those numbers to me?
Yes, Your Honor.
Okay. All right then. So since May 2015, defendant has accumulated child support arrearages in the amount of 17,822. So that's where we're starting. Give me the date of this order again.
This was April 26, 2017.
2017. Okay. Okay. 2017, 1782. Okay. That's 17,822. Was that as of the date of April? Was that number as of April, or was that number as of another date?
No, Judge, it was
As of
as of April.
That was the April date. Okay.
This
All
was as of April 24th, 2017.
2017. Okay, so that's the number. All right. Now let me see your that summary that you have, Ms. Koski.
Yes, Your Honor.
17 is the number that's outstanding. And these right here are, so we're adding 17 plus 6,399. Is that what we're doing?
No, we're adding, can the court see my shared screen, Your Honor?
I can see your share screen. Mhm.
Okay. So at the time,
Let me stop sharing mine, Ms. Costa, because I can't see it. So let me stop sharing my screen.
okay. So at the time we came to court, there was 17,822.
Right.
What since became due from 4/17 to 5/20, that's when the child support obligation would have ended, was 27,018 plus the 1,500. So his total obligation would have been 46,340. Make sense?
Yeah, but no, I think you made a mistake. Go back to your go back to that
Yes, here we go.
so that okay, let me ask you, that 17, where are you getting that arrears from? Because if you're adding in, so he already owed the 5,000, so he's just purging 5. That should be a new 5. He's purging 5.
Right, but that's when he paid it, because he didn't pay it at the time of the court hearing. So he had one payment in April, which we gave him credit for, and one payment in May. The 17 didn't include that 5,000.
So the 5,000 was deducted from the 17.
No, the 5,000 should have been deducted from the 17.
Correct, and that's what we did. That's what we did here. It's so
Okay,
this.
tell me how'd you do that?
Right. So here he gets a $2,000 credit off the 17. He gets a $3,150 credit off the arrearages, and so on and so forth.
Okay, so that line right there is the arrearage obligation and how much he paid towards the 17.
Correct.
So you subtracted the 62 from the 1,000?
I subtracted the 62. Say that again, Your Honor.
So you
This is 6,200.
Go back to your front page.
Sure.
Okay, you see that 27,018? Tell me how you got that number.
That is $711 times however payments he had until the child aged out in May 2020.
So you did that 27 was just based on the 711.
Yes, Your Honor.
Oh, okay, now we're on the same page. Okay. And then the total firm garnishment, that 49, that's all the amounts that he has paid. You just you put it all together.
Your Honor, and I couldn't use Mrs. Noelling exhibit, and that's one of the things that we had in 2020.
Right, I get that part. But the total garnishment that you're looking at based on your records, I'm not talking about the volunteer payments, because I can understand that's going to be off because you got to kind of go back through everybody's records. But the garnishment, that's real numbers. Those are real numbers. You should get that from the STAR account, right?
That came directly. And that is updated as of 2 days ago, Your Honor. This was produced by DHR 2 days ago.
And Ms. Noella, is that number, do you contest that STAR number of 49?
Those were the payments that were garnished from his check, but those don't include the voluntary payments. So we don't contest that number.
I get that part. Okay, go back to the front one more time. So the voluntary payments, your position is that 35 should be what?
I think those are voluntary payments that
No, I'm asking Ms. Noellen, what is the voluntary payment number that you came up with?
The overpayment number that we have is
not the overpayment number, not the overpayment.
Oh, I'm sorry.
The volunteer number paid via check or money order, however you did it.
Oh, I see. So I called it the child support payments directly from clients.
Yes.
Those were $14,600.
What Ms. Koski is showing her position is that I show 3,533.62. Somebody give me the difference between that. So
Well, Judge, so we have, what I received from Ms. Noeline in carbon copies was a total of 7. So 1 second, please.
And so I think the confusion with me and Ms. Koski is that we did our calculation columns separately. So my office did similar to Ms. Koski, the child support obligation number, and instead of her 27,000, we got a number of 26,307. So we're off one payment. I don't know why, but we're off
That's
one
because
payment there.
this child has a late birthday and he graduated in May. So we went all the way
Right.
to May, not to the graduation. But the carbon copies that you gave me totaled 7,808.87 carbon copies. But the only thing that we were able to show in her bank statement as cashed was 3,533.62.
okay, wait a minute. So you're saying you don't even show 14,600.
No, Your Honor.
And Ms. Noeline, you're saying you show 14,600.
Yes, Your Honor, but my 14,000 includes all of the payments that Mr. Manzanares made directly that were not garnishments. So that includes the 2,000, the 3,000. It includes all of the $150 checks that he paid. So anything that was not a garnishment directly from child support services, we
Okay,
put
and so
under.
Ms. Koski seemed to say she's already given credit for those numbers, and I don't think there's any confusion about those numbers. So her position is that actual funds that are not accounted for through some type of I guess IDO process. It sounds like her position is that number is
7,000.
7,000, but her position is that she can only account for 3,500. That is, there's about $3,000 is unaccounted for.
4,275 we
Okay.
cannot trace onto the bank account.
Not trace. So what my question is now I want to see her position is that as of August 2022, the obligation that he had was paid in full. Go back to August of 2022.
So as of August of 20, I'm sorry, we take the position that it would have terminated July 2023. That's when, but what I don't know, and we just did it as a 150 payment because the order didn't address, was whether or not once the child aged out May 2022, whether he was supposed to continue doing the 711 and the 150 until paid in full. And that was my mistake. I drafted that order. So the court, I should have included an extra paragraph in that order that said, at such time as the child ages out, then Mr. Manzanares' monthly obligation should be as follows.
Okay, but for right now, we already know by another order that the arrearages would only be 150 a month.
Correct. And so that's how I treated it.
Yeah. As of August 2022, how many voluntary payments had he made?
No, he ceased making all voluntary payments May of 2020.
May of 2020.
Mhm.
So,
And that's when the child support ended as well. So there was no more child support.
How much voluntary, did anyone ever add up what his voluntary payments were from the beginning?
I did, Your Honor, but I gave credit only to what I could trace in the bank account. If I give credit to the carbon copies, which I don't think I should, I come up with 7,808.87.
Okay, but you're giving your copy credit is only 3,500.
Because that's what my client deposited in our bank. That's what I have as negotiated. I never received canceled checks from Ms. Llewellyn to show that the other checks were negotiated.
All right, now the arrearage obligation of 150, how much of the arrear obligation did he pay from 2017 until the end? What was the arrearage obligation? He paid 16?
Mm-hmm. Yes, Your Honor.
Uh-huh. And he was supposed to pay on that arrearage obligation 17. So isn't he?
Yeah, so that's what we can't account for. And we called the HR to see if we could help. They attributed to the 150 fee, but that doesn't make any sense because out of all of these garnished payments, he was also garnished an extra $1.50 every payment. But those are obviously that's the DHR fee. That's not anything that my client received.
Okay. So the garnished wages on the side. So like February, $1,500 was garnished.
Mm-hmm. Yes, Your Honor.
Oh, in 2023.
Yes, Your Honor.
Okay, go back up one. The 150. Okay, go to 2026. Go to 2017 one more time.
Yes, Your Honor.
Okay, there we go. Go to the total. What's the total garnished wage?
49,362.
49,362. And the child support, what he paid was 27.
Yes, let me bring that up again, Your Honor. There you go.
Vanessa, Ms. Costa, you have an extra payment for the child support obligation because you included April in that number, but he had already paid April. when we entered the order in the end of April, because his
Well,
payments are due on the 1st.
Yes, so
And the order had him started in May. So you
So
just have, on that 27,000, there's just one extra child support payment of 711. So it should be 26,000.
I don't show that when we went to court, he'd actually paid the April because he was still tracking arrearages. It's just a couple $100 when we were talking about, I don't know.
So your position is that he didn't pay April of 2017?
Yeah, because he was not paying any support when we had to take him to court.
Okay, so let's just hold that right there. Let's hold that thought for 1 second. Okay. So his garnishment, theoretically, was supposed to be taking funds for the amounts that he paid each month, 711 plus any arrearages.
Of 150, at a rate of 150 Your Honor.
So show me at the point where his garnishment, where he had paid 17,822.
Well, it was past his, the expiration of his child support obligation because his obligation went past the age of majority because it was so much and the repayment was so little.
Yeah, but go back to
Well,
go back to
Ms.
your
Koski's chart.
go back to
Ms.
seven. I want
Your Honor,
to.
Ms. Koski's chart doesn't, question you're asking is at what point in time did his 17,000 arrearage become paid?
Right.
But Ms. Koski's, the way she organized her chart, we can't know that number.
Well, yes, you can. Go to 2017. We should be able to at least kind of guess. Now, let me ask you that $2,000, that was, where did that $2,000 come from?
His initial purge amount in April.
He paid that to whom?
To my office. And obviously I paid it to my client.
And the 31, how did that come through?
Okay, so the 3150, it was 3,000 for the purge and then 150 towards the arrearages.
So, and then the IDO didn't start until July.
Correct.
Correct.
Correct. Because it takes a couple of weeks for it to kick in.
Right. So basically, at the point where he pays $12,000 from, I mean, it's kind of difficult to kind of figure that out because you also have the 711, which is taking in consideration and he's not, that 711, he's not paying that separately. Like when we're looking in 2017, the only funds she's getting is through that garnishment.
Yes, Your Honor.
Right.
And so went to Ms.
In
Noel's
2018,
point,
he did start paying separate because they were not taking enough money out of his garnished wages.
But if
So
you look here,
and that's where the volunteer payments start coming in because the garnishment is only taking like a few $100 out of it, and he owes $7. So,
right, and so if you look at
he's going to get caught up at some point because the garnishment is not doing enough.
And if you look at
and I made sure I told him, you need to make sure that the 711 plus the 150 that you pay that every month. What I didn't know, because he said he was paying, was that he was making it directly to her and not to the child support office. I didn't know that until August 20.
Here's what I would say, because the numbers are combined and you can't extract them. Like if I'm looking at the garnishment, okay, in July he pays $138.02. I can't say to you, oh yeah, $38 went to the arrearage and $100 went to child support. I wouldn't say that. In fact, what I would probably likely say is all of that money goes towards the current bill. So I wouldn't even touch the arrearages. I wouldn't even consider the arrearages until he's paid the actual amount of child support obligation that he had to pay. So that would be a 711. So if I put 711 and I multiply that, what is the amount of child support he was supposed to pay from 2017 until 2022 when the child averaged out? What is that number?
Yes, let me go back up. But before I forget this point, Judge, if you look at 2017, after we went to court, he continued to accumulate arrearages.
Right, of course. That's what I'm saying. That's the reason why I'm saying I wouldn't even think about the arrearage. Well, he's not really accumulating. Well, yeah, because he's not paying the 711. So I would say I wouldn't even think about them being arrearages until I get the 711 paid. Right. So from April 2017 until this child support obligation ended, which was in May of 2022?
2020. The basic child support obligation ended May 2022.
Okay, so from April 2017 until May of 2022, how much money was he supposed to pay in child support?
Let me correct myself, Your Honor. I'm so sorry. When we start off with our, when we put this summary together, this is a summary of what the order was, but where there is this summary here was post order. And so in 2017, after we came to see Your Honor, Mr. Manzanares accumulated yet additional past due obligations. Right,
because the garnished wage 900. The garnished wage is not taking out the 711. So every month he's $500 behind.
Right, it's more than just $700 because if his basic child support was $6,399, and then the arrearages, and then the attorney's fees, and he only paid 1,838. So it was in the thousands.
Yeah, but the arrearages, you gotta think about it. The arrearages money is already have been paid. You don't owe that again. It's just money that you owe on top of the 17. So the arrearages don't accumulate, they just don't decrease.
No, he acquired new arrearages
as a result of not paying the 711
in 2017. Mm-hmm.
Right. But what I'm saying is if he misses the 150, you don't subtract it. You don't add it again.
Correct. The only thing that we would add would be the basic child support that he missed.
Right.
Yes,
so he was supposed to pay $27,000 from April of 2017 until May of 2022, correct?
Yes, Your Honor.
That's the number I want to know. When did he make 27,000? When was that number? When was the number made?
I can tell you in just a few moments, please.
Okay.
So by the end of December 2021, in garnished wages, he had 20,902. So I am missing, how much am I missing?
I'm looking for 27,000.
Yes, hold on just a minute, Judge. Okay, let me write that down. So by December, he paid 20. I need to find another $6,000. 1 second.
Mm-hmm.
I would say roughly by June of 2022, he would have satisfied his basic child support obligation of the 27,000.
Yeah. So by June of 2022, so he would have still had, he would still be paying. He wouldn't pay because he's now after we go through his basic obligation of paying $27,000. Now he has to look at his arrearage. His arrearage started at 17, but he paid 5,000 up front. So he owes about 12. So as of June of 2022, now you got to take out another 12. I'm not even gonna look at his voluntary payments because that's the issue of contention and whose issue it is that he's paying it that way and not making sure credit is being done. We'll deal with that later because that's the voluntary piece. But for right now, I'm looking at whether what the IDO should have done or what the IDO knew at the time, or I should say IDO, but what the department knew. So on June of 2022, now I want you to take out another $12,000. Tell me when another $12,000 hit for him to take it out, that 12.
Yes. 7, 6, 5.
Your Honor, I'm sorry, the date that Ms. Costi gave is not correct. And again, it's just the way that her chart is laid out doesn't allow you to make that calculation.
Well, I'm trying to figure out when $27,000 was garnished. So at the end of every year, she has a total number. Do you disagree with that total number?
So I don't disagree with the total number.
So go back up to 2017. So see her garnished wage right there is 1,800. I'm gonna use that. I'm gonna round it off, but that's 1,800. The next year in 2017, she says his garnish was 5,000. I'm gonna use that number as a round off. So at this point on front page, front page, I have $1,600 in garnished wage. So I'm now gonna go to the next one. The next one I'm looking at 4,000, so I'm at 10,800. Looking at another 4,000, so I'm at 14,800. That's how much I have in garnished wage as at the end. Now I'm gonna add another 6. That's $20,000 in garnished wage. 20,000. Now the garnished wage of 1, so that's 20. So now I need to get to 7,000. So that's 1, 2, 3, 4, 5. Probably about around June.
June 2020.
By the end of May of 2022, that's when I have gone over $27,000 in garnished wages. Because you can't separate them. It's garnished wages. You can't separate them. No one's going to say, well, you know, the 711 is for this and X amount is for this. You really can't. You just have to grab it all together. But your daily expectation has got to come first. That's just clear. And then you're going to do that second. So if I look at where he met his basic obligation, it would be in June, maybe between May and June of 2022. Now I'm going to start putting everything he has. I'm going to look at what he owed for his arrearages, and his arrearages, we already know that basic number is 17,000. That's the number we're going to use, but we're going to go ahead and take off 5,000 off the rip because we know he paid that to her. So that's 17 minus 5. So now he owes about 12. He paid about $150 in small increments. So he probably owes, $11,700. That's how much money he now has to pay off in arrearages. So if I take off May, that's $1,400 in May. So that's 2, that's 3, that's 4, 5, 6, 7, 8, 9, 10, 11, 12. So probably by the end of December of 2022, that's probably the first time where the garnishment is taken care of. And now we're looking at just that straight money of 2022. Go to 2023. Yeah. So 2023, that's probably, you're right. So that garnish, if you look at 2023, these garnish amounts, probably about 10. You're probably looking at about 10,000 that he's overpaid.
Well, but so that's where and I understand what you were doing, Judge.
Yeah.
But the total amount garnished from DHS was 49, and then I go back here and I see his total would have been 46. So that's about 3,000. But you are correct, Your Honor, that 5 didn't get taken into credit. Make sense?
Yes, so 5 should have been taken. Yeah, it should have been credited, but it wasn't. So
Right.
what I'm saying though is that the issue becomes, should that IDO have stopped? And I'm saying that IDO probably, if it should have stopped, it would have been in 2023.
Correct. Correct. And when it did stop was July 2023. And that's been our position all along. When Ms. Noelle called us, the obligation had not terminated.
So
And
Ms. Costi, that's the problem. The IDO still has not terminated. So the fact that the accountant stopped in July of 2023, that's when he quit the job. So
I
the
don't know that
introduction order is
DHR
still valid.
I don't know that the HR would
If
be
he were
able
ever to go back to that
garnish.
job, or if for some reason DHS continues pursuing this, they have an unmet IDO that's still active.
Well,
The only stops taken.
I think you did right, Ms. Noellen, when you filed the motion to stop the IDO. And I because I'm kind of, the way I'm looking at it is here, that there is this overpayment because, what I'm trying to say is that the department can't stop the overpayment based upon voluntary payments that he's given to mom without evidence that he gave mom those payments. And then they normally will do some type of, what do you call it, when you consult?
They'll do an investigation.
Yeah,
based
they'll
on
do
the
an accounting and try to figure it out. I don't know from Mr. Pedro why, when he went to them in 2022, they wouldn't do it, other than the fact that they recognize he still owed money. But even if he still owed money, if he has evidence that he paid mom some extra funds, those funds should be considered. And I say should because there are some people who will give extra money for their kids, and it's not child support. It is a voluntary payment. I'm giving you this because I want you to get shoes. I'm giving you this because I want to get clothes. And they're very particular about not adding those numbers in because that's not child support, and unless that person accepts it as child support, which I think to some extent that is what she was doing, because I think she understood that the IDO wasn't taking off as much money. But what I'm saying is that might be the department's reason why they didn't move like they should have, because there should have been some type of accounting, particularly if the mother was not particularly if the mother was not contesting the fact that he was giving her monies to help offset the child support, not for voluntary purposes. You know what I mean? Like if she's saying, yeah, he's not giving me this money for childcare. He's not giving me this money so they can go to camp. They're not giving me this money because I'm supposed to pay, he told me to go school shopping. He's giving me this money to offset my child support amount. That should be taken into consideration by DHS because generally they will do those accountings. Now, I do know one other thing too, is they don't do them off cuff. They do have a time frame in which they do those modifications. Like, I don't know if you just walk in one day, if they'll go, oh, let's just redo this. I'm not sure about that. You guys will probably be better equipped to answer that and kind of figure what they do, because I kind of feel like they got so much going on. They may not stop everything and redo an accounting. They may do a modification. They may do something on a calendar. They may bring the mom in and do those sorts of things, but it may not be, something that's instantaneous. It's what I'm trying to say. So,
and I will tell you, Your Honor, that the petition was filed and my client was served in June. And so my client delivered the petition to DHR, and it took them a couple of weeks, but then the last garnishment was 7/31. Now, even if my client, and she's not going to do this, were to present this IDO to DHR, DHR can't reinstitute the IDO when, number one, they have clear proof that the obligation's been met, and number two, that the children both have aged out. So I don't see in any world where they would put in place yet a new IDO.
Yeah, but the point is, Ms. Noelle is asking for it to be terminated, and it should be terminated. So that's no big deal. It should be terminated. There's no more obligation that he has to be met, and we should terminate the order. That to me is clear. I think the issue becomes, and what I'm hearing, because I think the termination of it makes sense. I think everybody is just confused as to when that should have happened. And even now I'm doing generalities. I'm just kind of adding numbers together and kind of seeing what would be the best scenario for someone to try to resolve this issue. But I do think they're clear overpayments, because we're looking at just kind of what I just did, like that quick little numbers game I just played. You're looking at $10,000 over for which he paid in the garnishment. And then we're also looking at another $3,000, $3,500 that even you acknowledged that was given by cash. So in actuality, he might have paid over $14,000.
We're forgetting about the $1,500 of attorney's fees. So we have to take that off.
Well, we'll take that off too, but I'm just saying, if you considered it, it would be about, he could, anywhere from $10,000 to $13,000 to $14,000 that he overpaid. The question is, Ms. Noellen's position is that it was voluntary. The question is, should it be returned? And I think that's all depends on, how this whole thing kind of worked its way out. That is, was there a point where someone should have known something? Was there a point where someone should have acted, and who should have been those actors with regard to it? And whether there's somebody who should, take on that responsibility, or whether they are voluntary. Now, generally, I think Ms. Costi is correct with regard to the case law on it. Voluntary payments are voluntary payments, but I'll take a look at the case law because I don't know if there are distinctions to be made in a case like this, wherein Mr. Manzanera has outstanding amounts that he paid that did not flush out, and or even if you exclude the $3,500, like it's just excluding those numbers, there were numbers that did not get included, and that's why the numbers kept going, such as that first $5,000. Somehow that $5,000, they took the 17. Think about it. They took the 17,000 as per my order. They probably did, and so they were expecting him to pay 17. They were not expecting him to pay 12. They were expecting him to pay 10. And so that is a confusing part. But does that mean she should pay those funds back? I don't know. So I need to look at the case law.
And so to your point, you Judge, if we look at this exhibit, the ones that we can give her credit for, and if you take 1,500 and you take the 5,000, I do believe that confirms our overpayment amount, because you are correct. The DHR document does not provide credit for the 5,000, and I don't know what anything Ms. Noelian and I could have done.
And as I'm looking at that 27,000, I just added it up. That 27,000 is wrong. That's wrong. That's wrong by a few $1,000, because April 2017, so you got April 2017 to 2018, 2018 to 2019, 2019, 2020. So that, hold on, did I say that?
That's 38 payments.
Okay, that is 30. Okay.
Yeah, that's 38 payments.
So 2017 to 18, 19, 19, 20. Okay, great. So
Judge, we've been doing this for 3 days, and my staff is probably going to quit because we all hate math. The amount of work that we put into doing this.
Yeah, you're right. Okay, yeah, that's right. Okay, so plus 7, 11. Okay, yeah. Okay, yeah. Okay, I see then the 2. Okay, yes, I see what you got.
Okay. The child support order does say that it was to begin May 2017, and it included all the arrearages up till April 24th. So just one payment over, but that's fine. It's $700.
But we still got to, so have you taken a look at the cases? No, I think you did. And your argument is that you don't consider the IDO to be voluntary.
No, Your Honor, it's not voluntary when, the department is court ordered to withdraw his funds and he had no control over it, even when he went to his employer and tried to end it, even when he went to child support office and they wouldn't help him. So that's not voluntary.
And that's why I put in my motion to dismiss that DHR should have been made a party of this action.
I do think DHR should have been made a party to this action. I kind of said that from the beginning. I didn't know you had made that request, but they certainly should, because they got all the numbers.
And this is their doing. This is their doing, and this is actually their case.
Yeah, it's definitely their issue.
The part that bothers me, though, Your Honor,
any cases about the when the department kind of continues?
No, Judge, the only case that I could find was, and it is a DeKalb County case. I don't think it's your division, Your Honor, but it is a Department of Human Services cases. It's a recent decision in 2023. And it was remanded to the court to kind of figure things out with DHS. But at the end of the case, and I certainly can email it to Chambers.
What happened at the end?
At the end of the
case. Was that the Colco case? Colco? Yes, I read that. It's not.
Yeah, well, it was a VA order and involved DHS, and DHS not giving credit for those VAs. And then it just said the general rule is these are overpayments. But I return to the following argument, Judge, that Mr. Manzanares should have parked himself at DHR and said, wait, I've overpaid. And had they started the case, then a letter would have gone to the non-custodial. My research and risk.
But that's the point why that's the reason why I think DHS need to be here, so we can know what the procedure was. I need to understand what that procedure was, whether Mr. Pedro did it. I don't know. Well, maybe you can put him up. Do you want me to hear from him? Because I can figure out what he did. Because I would like to see what DHS position is when he walked into that office and said, hey, I have this overpayment. Did they give him a form? Did he complete it? Did he turn it back in? What is DHS position on why they didn't stop it if he came in with evidence of overpayment?
And
I'm fine with that, Your Honor. But I also feel like Ms. Alarcon is made to be an innocent party when she's not 100% innocent. Because as of August 22, we spoke with her, we spoke with Ms. Koski, and they were aware that our allegation was that his obligation had been fulfilled. So at that point, she knew, okay, it is fulfilled. And, even if, supposing that we were a few $1,000s off and it wasn't fulfilled until a few months later, she still continued to receive these child support payments for an additional year, thousands, some months, knowing that there was an allegation that she was not entitled to it because his obligation had been fulfilled. Okay. So I think the case law that exists is to protect an innocent party from not knowing that they're getting this money that they're not supposed to get, and then, oh, I have to pay it back. I didn't even know I wasn't entitled to it. She knew she wasn't entitled to it.
What's your position on that, Ms. Kowski?
Judge, when we got the letter that Ms. Noeline published, we did the math, and her math was off by about $12,000 because it didn't start the calculations until 2018 and didn't consider additional arrearages accumulated. And so we did not believe that in August 2022, what the obligation would terminated, and that's clear from the evidence. The obligation would have not terminated until the following year. Notwithstanding, that was sent over to DHR. DHR confirmed that there was still obligations outstanding and the IDO could not terminate. Now, when the carbon copies, we could not confirm. They're carbon copies. They're not, but even as of for today, we did the diligence and looked at 36 months of bank statements, which we have into evidence, and we could only allocate for 3,000. So at the time that she wrote us, we still had another year, even with the overpayments. So it's not on my client. Once we were served, that was served on DHS, and DHS did what they needed to do. But I don't know how.
Can you show me? Can you show me your scale one more time with regard to the garnishments and the total starting in 2017? Let me look at it real quick again.
And again, Your Honor, my client is not the savviest, and my staff all have degrees. I certainly have 3 degrees, and this took us 3 days. I mean, it took us 3 days to sort through all of this, so I can't put it on Mrs. Alarcon to have done this.
Ms. Nolan, what made Mr. Manzanera come to you? What made him say something's wrong?
So he first called, I believe, in 2021, saying that his child aged out, which he had the year before in 2020. And I said, well, yes, we still have these arrearages that you have to fulfill. So we ran quick numbers. Like, probably took half an hour and ran, okay, from May 2017 to May 2020, when he aged out, graduated high school, 3 years of payments that came up to 26,000 something. Then plus the 17,000 in arrearages that came up to, is it 46,000, 43,000? 43. And then we looked at the number that he had already paid and said, well, you're not there yet because you still had, I don't remember, Your Honor, let's say 5,000 in arrearages left. And then after he did that, paid what was left from the income deduction, then he came back and said, here it is. So I said, well, you need to provide these payments and go to the child support office. And he went to the child support office several times. He got reports of his payments. He said they wouldn't help him. He said he came with all of this paperwork, which we provided to Ms. Koski, trying to get the matter resolved. And I'm sorry, Ms. Koski, but I have to say it, like, if you had only communicated to me, we could have sorted this out. But I received just zip communication.
We communicated with you, and we believe that the obligation is not done. But
no, all your office is said is contact Ms. Alarcon directly.
No, we wrote you.
That's it.
Okay. Well, again,
Ms. Koski, I promise. All your office said when we sent you the letter is contact Ms. Alarcon directly and save your stamps. Don't even mail us the letter. That is what your email said.
But were you still her attorney, Ms. Koski?
My obligation terminated back in 2017, and I didn't want her to spend the thousands of dollars she spent today because DHR should have resolved it. That was my position all along. If there were overpayments, DHR collects a fee to collect, and she handed the lawsuit last year. They did what they needed to do. The year before, when she received the letter, I said, go to DHR, and DHR said it's not done yet. I mean, I don't know what else I'm supposed to do. This is a DHR case. I think DHR should have been here to answer some questions. And if DHR, and I really very much doubt that DHR said, sorry, we can't help you to Mr. Manzanera if he is alleging thousands of dollars of overpayment. Because
do you know if they had
at that point, it wasn't thousands. In 2022, we had calculated over $1,000 in overpayments.
Do you know if did they provide interpreters when he came in? I mean, did he have an interpreter?
They have a language line. They have Spanish speakers. That's never been an issue with DHR. God knows they have a bunch of Spanish speaking staff. That's never been an issue. It's been my experience in other cases when somebody says, hey, I don't want the IDO anymore. They go, I don't want the IDO. They sent a letter to the custodial parent. Or I have won the lottery and I've overpaid. They send a letter to the custodial parent. The problem here is Mr. Manzanera had, I don't know how many we counted, carbon copies. And those carbon copies were not evidence that they could use. They had to have canceled checks. I think that was the problem. That he did not.
Let's put up Mr. Manzanera and see. Let me hear what happened. Can you unmute, sir?
Yes.
Tell me what happened. You put your hand down.
Puede bajar la mano.
Okay, yo fui en el 2021.
In
Fui en el 2021
I went
allá de Child Support y me dijeron que mi caso ya no lo tenían ellos.
and they told me that
Que
they
nada
no
más lo
longer
tuvieron
had
hasta
my case,
2017.
that they only had
Que
the
mi
case
caso era
until
un caso especial.
2017, my case was an
Y
exceptional
que tenía
case,
que tenía que ir a regresar con mi abogada y volverla a
and that I
contratar
had to
para que ella
go
abriera mi
back to
caso.
my attorney and contract her again so she could take on my case.
Fui a la corte a conseguir una
I
hoja
went
de
to
que
the
se
court
podían poner mi child support también y me dieron una
to
hoja,
getting a
pero
sheet of
y se la
paper
llevé
about
a
the child
a
support,
mi empleador, pero
and I gave
él me
that
dijo que
to
no
my
podía
boss,
pagar, que
and he
hasta que
told me he
tuviera la
couldn't
orden de
stop
la
it
corte,
until he had the order
la
from
de
the court.
usted. Y fue que contraté a la abogada Noelín
That's when I
para que
contracted the
abriera mi
attorney
caso.
so that she could help me with my case.
You're saying they said your case was exceptional?
Usted dice que ellos le
Ya,
dieron
es lo que me
una
dijo
presentación.
child support.
Yeah, that's what child support told me.
Do you know why they said that?
Ellos me entregaron la hoja
¿Sabe
cuando-
por qué lo dijo? ¿Por qué le dijeron eso? ¿Sabe usted?
que porque el caso lo tenía directamente la corte.
Because the case was directly from the court.
Judge, I think there was a misunderstanding. I think he said that
Yo
the
creo
case
que hubo un
was
malentendido,
closed.
que el caso había sido cerrado.
I'm
Sí, mi
understanding
caso
that
había
they're
cerrado
saying
desde
that it's a court
2017.
case.
Yes, the case had been closed in 2017.
And
Is
again,
that
Ajá,
because
lo que
there
dice
was
la
a
abogada
court
Noelín,
issued
eso
child
es verdad.
support order?
Eso es porque ya teníamos la orden de manutención que vino de la corte.
DHR wouldn't have told us the
Ujú.
case is closed if they're still collecting on it. It's their
Si
IDO.
todavía están cobrando por descuento directo, ellos no hubieran dicho que el caso estaba cerrado.
Okay.
I don't have any experience with this really, Your Honor, but if it's a DHS case, that means it's their case that they have opened in a special section versus just collections on a court private case. Is that what they could have been saying?
Now, this was their case all along because Mr. Manzanares never legitimized. Mr. Manzanares, Mrs. Alarcon filed child support before you and I were even involved, and DHR filed on behalf of the children and sued Mr. Manzanares. So it was their initial case. I think that there is a distinction when, for example, I have a divorce and the parties agree or the court orders an IDO. That's a private case
Yeah.
that they don't monitor. But this, if you look at the initial pleadings, this was a case initially brought by DHS. So it originated with them because the caption in the 2008 case, Your Honor, I can actually publish it.
But you doing the contempt action. I'm wondering, by Ms. Kosky bringing the contempt action, a private action, and filing the court's income deduction order, did that somehow convert it in their system from a DHS case to a private case?
It could have.
Maybe, but the consent order was still through DHS because the reason I got involved was because Mr. Manzanares, I think there was an issue of why they could not confirm wages through the Department of Labor. So DHS has the ability to confirm wages through the Department of Labor. So when they couldn't confirm, they could not issue an IDO, and I got involved privately, but it was initially their order. But that doesn't mean that they closed their case because we have their garnishment. They're still collecting and distributing. They're still making the 150 fee.
Ms. Kosky, we may never know what happened, but the issue remains that they refused to help him, which is why he eventually hired me.
I mean, my client went a number of times. And I mean,
what happened with your client once again?
My clients, the case was still open and there were still arrearages. And I don't know that
that's what they said to her.
That the case was still opened. And my client wouldn't have, like I said, it took us 2 days to do the accounting. So I don't know that she would have been savvy enough to have done that. Plus, I don't know that she would have been savvy enough to do that.
Okay. All right. So, yeah, let me look through the order. Think I've gotten as much information as I can. And Miss Marshall, I have Miss Kosky's exhibits, right?
Whatever she would have emailed to me, allow me to double check before we get on.
Yeah, just make sure you have
I have not, but I will immediately.
Oh, okay.
I stopped sharing. I didn't realize I was still sharing when I was looking at other stuff.
Okay. All right. So, I got what I need. I'll look into it and try to figure out what would be the best way of handling it. If I see anything in the order that's kind of alarming, I might open it back up so we can bring in DHS and try to figure out what their accountability in it might be. And I'll look into this issue, IDO versus volunteer payments, and how that is, how that should be viewed. Okay. All right.
We can do a, I mean, if it helps out Ms. Noellen, we can do a simple order just saying the IDO is terminated. I mean,
Oh, yeah, that's fine. Yeah, we definitely want to do that. Ms. Noellen, if you can just send that to me, that's no issue. I think the
Yes,
issue,
Your Honor.
Ms. Noellen is also asking for the money to be returned. That seems to be the larger issue. At least that's what I was thinking through the day. The idea of it being terminated, I think that's simple. The issue is whether or not Ms. Alarcon should pay the funds back. That's a larger issue because I think if you note it, generally you don't pay funds back if they're voluntarily given. If there's a mix up, it kind of is what it is. But Ms. Noellen's position is that the IDO makes it not voluntary. So I don't know how that is generally viewed. But I also recognize that you have two kind of lay people depending on the government to work, and then if it doesn't work, what the issue is. I think Ms. Noellen's position is there was at least some point where she recognized that this was coming to an end. I think the real issue is when,
and Judge, and I don't
to recognize what that when is. So and I don't have an answer right now. I just got to do the research on it. I don't have an answer.
And I don't know how we punish my client for the departments.
And I get that. And I guess the other side that should he be punished for giving monies that he had no control over stopping? So I think the side money is a shorter issue. That money is voluntary, but you have the IDO money that's could be potentially upwards of $10,000. That is the argument that Ms. Noellen is making. So I need to look into it. But I do get it. I get somebody's going to be, there's a hardship on someone, and the question is who should that fall on? So let me just take a look. Okay.
All right.
Your Honor.
All right. Thank you.
Thank you, Judge.
Ms.
Thank
Harris.
you.
Thank you, Ms. Harris. You've come to office.